Supplementary list, old matter, item number 1.
Item 1, my lord, I have no instruction with the liberty to approach your lordship.
What liberty, sir? No instruction, no instruction. No instructions dismissed. All right.
I pray you lordship may kindly consider my.
See, PIL,
I don't think
sir,
that.
In a PIL, suppose we don't give liberty, can anyone prevent a PIL being filed? So what is that? Item 2. Item 2.
May I please, Lord? The input order is at page 352, annexure 5.
Xerox copy of pages 121 to 124 illegible.
I'll submit my.
Way back in February 2018, judgment was passed. It has not been admitted till date. Contempt application is pending. No stay has been granted.
I see. Okay, tell us what the matter is. All right, tell us what the matter is.
Page 352.
Your own Khadi Village Industries Board you are fighting?
Yes, we are fighting for the state government.
I know, against this Khadi Village Industries Board.
Employees.
Okay.
What has happened, my lord, that ORSP rules 1996 and ORSP rules 2008, that has been extended them to subsequently. The Honorable Court has directed to extend them with effect from 1/1/2006.
With Lordship's kind permission. Usually in last occasion also in one matter, for last 1 year the matter was not listed, no interim order of stay has been passed. Lordship, what action you have taken to implement this? Here is a case of 4 years.
Your Lordship has heard this matter several times. For that reason, both have appeared. For that reason, stay has not been granted. All have appeared in this
but
case.
Still,
several times.
You ought to have implemented by now.
But it has been, they have been. And it has been heard several times. My Lord Senior has appeared from as a caveator.
Not before this bench.
No.
No, for several times.
It has come first time before my lords.
Yes. Tell us. I think it's better we finish it off.
Yes, my lord. Your Lordship, turn to page 352. The input order.
See, other boards are getting monetary benefits.
Yes. Well, I'll draw my lord's notice. My lord's have turned to page 364. What are the points for consideration before the Honorable Single Judge? Lord's
whether employees of the board are at par with state employees.
Whether the employees of the board are at par with the state government employees and are entitled to the benefits so far as the revision of scale of pay and other allowance available to the government employees. Whether the employees of the board are entitled to revision of scale of pay and DA in terms of ORSP rules 1998 and 2008 with effect from 1/1/96 and 1/1/2006 respectively, and release of arrear salary and allowance from such date respectively. This is the point, in so far as first point is concerned, Lordship, see para 23.
Yes.
The regulation prepared by the board in 1960 clearly showed that it is a schematic one. This regulation has been made to regulate the service condition, including salary, etc., of employees of the board. Clause number 8 and 40 of the regulation states as follows. Classification of employees. The employees of the board fall under two categories, namely regular establishment and schematic establishment. All posts under the board shall be classified by the board into class 1, class 2, class 3, and class 4 as specified in Schedule 1 thereto annexed, provided that at the time of creation of a new post not mentioned in Schedule 1, board will specify the class under which the post will be included. General conditions of service, unless otherwise provided in these regulations, the rules in the Odisha Service Code Volume 1 with all appendices except Appendix 1 to 4, 8, and 12 as amended from time to time by the government shall apply to the employees of the board Mutandi. For this purpose, the word government and government servants and head of department whereof they occur except in chapter 1 of the code shall mean the board, the employees of the board, and the president respectively. For your service referred to in Odisha service shall mean post in class 1, 2, 3, and infra shall mean post in class 4. From the aforesaid provision, it is clear that the staff of the board is to be accepted as government servant. Because of that, they have adopted the Odisha Service Code. Honorable Single Judge said they are government servants.
No, what is your answer to that? Why should they not?
Because they are the employees of the board.
Whatever. So why should, if they, for all practical purposes, they are going to be treated as government servants? Practical purposes.
Yes, ma'am.
What is the problem
Yes,
in
ma'am.
according to the status?
Yes, ma'am. If they will be, once they will be treated as government servants, then they are entitled to pension.
Exactly.
In one case, if that your lordship has allowed their pension and directed to grant them pension, that was allowed by my lords, and that has been stayed before the Honorable Apex Court.
That is all right. That
So,
is anyway. That's a
once-
different issue. Whether ultimately the Supreme Court will permit it or not.
Yes,
That's
ma'am.
different.
Now, what I want to submit, my lord, if once they are declared as government servants,
No. That's how they've come to the court.
my lord,
They've come to the court saying, don't discriminate. For all practical purposes, you're treating us as government servant. Only for our pay and allowances, you're not giving us the same pay and allowances.
because they are completely regulated by separate regulations.
Maybe.
Yes, ma'am.
In fact, that is what is being tested.
And they are the employees of a board.
Correct.
Once they are treated as government servant, then they are entitled to all the benefits that are to the government servants.
That is their argument, sir.
Yes, sir.
That is their argument. Why should that argument, why should it be negative is the question.
Once my
No, but there must be a rational basis. This is the Article 14 argument.
yes,
There must be a rational basis to say, I'll treat you as government servant for everything, son, but except salary, I will not give you. I will treat you as employees of a board, and I'll say board is not government, and therefore I will not give you salary.
but
Which is what has brought them to the court.
what was their problem? My lord? They are not extend the benefit of ORSP rules 1996 with effect from 1/1/96.
Yes.
That we are extended them with effect from 1/1/2000. Though we have extended them from 1/1/96, but financial benefit we have extended from 1/1/2001.
So what is the logic? What is the logic?
Because of that was not only ORSP rules is applicable to the government servants.
Again,
And
sir, it's again same.
Yes, ma'am,
You're going in
Yes, ma'am,
circles.
unless that they are government
You
servants.
must explain a rational basis for denying them that benefit. That's all. Where is that rational basis? You can't say, no, they are board employees and therefore. That is not a rational basis. That's why they're coming to the court.
They are the board employee and they are paid by the board. And we only
They are not denying. Who is denying that?
And we release the granted only to the board.
Whatever, sir.
Ma'am.
Question is, if government servant is getting 300 rupees, why should they get 100 rupees for doing the same work?
They are regulated by their regulation.
That is the whole thing. So are those regulations fair? Can they pass the test of Article 14?
Yes, all employees are to be governed by their own set of regulations.
Correct. But if they, for all practical purposes, then don't treat them as government servants. For everything else, you want to treat them as government servants. When it comes to pay, you say, no, you're board employees, you're not government servant. They are questioning that.
The regulation is different. So
That's how they've come to the court, sir.
no, for that they have come in 2001. We have extended the benefit of ORS rules from with effect from 2001. That is they have never disputed their regulation. They have never challenged their regulation.
Why should they?
And they are the employees of their board. There is no dispute about
You
it.
yourself have clarified in the regulation that they will be treated as government servant.
No, that
Regulation 40.
regulation, they are not government servants. You also may say they are the employees of the board. That unless otherwise provided in the rules in the Odisha service shall except amended from time to time, the government shall apply to the employees of the board. For this purpose, the word government servant, my lord, and heads of department wherever they occur except in the shall mean the board.
Which means what? That's the same thing, sir. You want to bind them down by all the conditionalities attached to government servants.
My lord.
But when it comes to pay, you say, no, you're employees of the board, you're not government servants.
No, my lord, what has happened? My lord, board makes its regulation.
Yes.
And board makes its regulation, they adopt the government servant rules.
Right.
So according to them,
So for pay also, why don't they adopt? That's the only question. When you adopt it for all your other disciplinary action and everything, why don't you adopt pay?
my lord, what has happened? My lord, government is to release the granting aid.
Correct.
Board has recommended for, but the government is to release the grant in it.
Correct.
And that's so far as your lordship knows that so far as financial condition is concerned, accordingly government has released the grant in it.
And you know that the settled law,
Well-
mere financial difficulty is not a ground to deny equality of treatment.
And we have extended them from a particular cut-off date.
That's it. There's no other argument.
Yes, that is the only ground. If your lordship will treat them as government employee,
All right. All right. You say two questions were taken up for consideration by the learned single judge in the impugned judgment dated 9th February 2018 in writ petition civil 4802 of 2011 filed by the respondent number 1. Then copy these two questions at page 364, paragraph. In answering question number 1 above, the learned single judge took note of the applicable regulations and came to the following conclusions. Reproduce whole of paras 23 and 24. In view of the above discussion, the learned single judge answered question number 1 in the affirmative. Paragraph. Learned counsel for the state appellant contends that members of the respondent number 1 union continue to remain employees of the board by virtue of the separate set of regulations, and that the government merely releases a grant to the board, which then makes the payment. Full stop. According to him, merely because the explanation to regulation 40 requires employees of the board to be treated as government servants for the purposes of disciplinary action would not ipso facto make them government servants eligible to the same scales of pay as government servants. Paragraph. The very question before the learned single judge was whether there is any rational basis for discriminating against employees of the board vis-a-vis government servants, despite subjecting them to the same regimen as full stop. Indeed, the learned single judge indeed the state was unable to place before the learned single judge any rational basis for this differentiation when it came to the matter of pay. And even before this court, no rational basis has been presented. Paragraph. In fact, question number 1 is also tied up with question number 2, where employees of other statutory bodies, that is the Mahila Vikas Sambhaya Nigam, the State Social Welfare Board, the State Hajj Committee, the State Waqf Board, the Sri Jagannath Temple Administration, the Utkal University, the University of Agriculture and Technology, and the Odisha Water Supply and Sewerage Board have been treated on par with the state government itself when it comes to terms and conditions of service of their employees. Full stop. In fact, counsel for the appellant state concedes that even the employees of the board have been given the benefit of the ORSP rules 1998 and 2008, but only from 1st January 2006 and not earlier. Full stop. Again,
2010. They have given from 2010.
From 2010 and not earlier. Here again, the state has not been able to show what is the basis for discriminating against employees of the Khadi Village and Industries Board vis-a-vis employees of all other statutory bodies mentioned above. And what is the rational basis for restricting the benefit of the applicability of the ORSP rules only from 2010? Paragraph. Consequently, even on point number 2, the conclusion reached by the learned single judge in favor of respondent 1 cannot be found fault with. Paragraph. The court is therefore not satisfied that the impugned judgment of the learned single judge suffers from any legal infirmity that calls for interference. The appeal is dismissed.
Item number 3. In this case, I am appearing
The
on behalf of
contempt
the
case, you say
opinion of
place-
2, my lord.
Just
For opposite party number 2, I am appearing.
All right.
For the
In that contempt case, you say placed before the roster bench.
only your lordship said direct because the matter is pending for last 4.5 years.
Yeah, you
Just
say,
fix up a time limit.
yeah. The compliance now be effected of the order of the learned judgment of the learned single judge positively by the next date of hearing of this contempt case, which
Yes.
will now be listed for the roster bench on 1st February 2023. It gives them some more time.
Yes, because your lordship,
Surely they will take it up.
we have digested for last 4.5 years. Why not another 3 years?
All right.
Contempt. Why not your lordship dispose of the contempt application?
No,
That, all right. Yes.
Right.
That's how better it would be done.
Item number 3.
Our appearance. Is your lordship.
Yes, please. Yes.
Item number 3.
None appears dismissed.
Item number 4.
None appears dismissed.
Item number 5.
None appears dismissed.
I am appearing in the second matter, my lord.
All right. First matter, you say none appears dismissed. Second matter, yes, sir.
first matter.
My lord,
First matter is regarding, my lord, here, my lord, this was the corporation which is known as OCAC, my lord.
Correct.
And they were the only ones where they didn't extend, although the board passed a resolution.
Okay.
So we went in a rate. The rate was dismissed because review was allowed. In the meantime, all the other PSU, state held, they were given 58 to 60. So I was given the 58 to 60. Now, my lord, what I am praying for, I leave it to your lordship. I am praying for only that 2 years that I have a weak case there, no pay, no work. So
Yeah.
I'll leave that, my lord.
All right.
But continuity of service, my lord, for the purposes of superannuation benefits, my lord, may be given to me.
Oh, this is your appeal.
My appeal.
Ah,
That, my lord, that I think, my lord, I have a difficult case that 2 years.
Correct. Yes, what is your appeal, sir, Mr.
my
Mantri?
lord, I have challenged my lord, your lordship may kindly see the writ judgment is at page 1.
Ah,
My lord, when they entered into the service and till the service condition was that the retirement age is 58, my lord. And it is a registered society. It only receives 1/3 granting aid from the state government, my lord. Then, my lord, when the state government increased the date of retirement to 60,
yes.
they filed a writ application claiming, he filed a writ application claiming that he should be permitted to retire at the age of 60. Lord, page 86, your lordship may kindly see, it begins from 87, my lord, the judgment in the writ application, my lord.
No, Mr. Monty, now in a review petition,
Yes, has been allowed, my lord.
no, you are against the order in the review, I thought.
Yes, my lord.
Ah,
I am coming, my lord. I am only drawing your lordship's attention to see that the writ application was argued and decided on the basis of the argument, meeting all points of the petitioner. Then, my lord, he came up in the review application, and the review application page is 251, my lord, is the judgment, my lord.
correct.
In the judgment,
Mr. Monty, if I'm not mistaken,
yes, my lord.
now the retirement age in OCAC is 60.
And now, after 2 years, they have given, my lord.
Then why are you contesting this judgment?
But now, if it is there, my lord,
Ah,
it will have a financial implication. As much as
No.
all persons, those
no, only those who make that claim will be tested. This is in his facts of his case.
they will come up again.
We don't know. They may or may not come up. We don't know. They have not yet come up.
No, they have not yet come up.
Then the question will arise in those cases. Why did they not come up earlier and all that?
It will be a precedent, and I will be bound by this.
No. It's for you as far as a policy call whether you want to pay arrears of salary to those who may have completed 60, but they have not come forward to lay any claim. So we should not imagine that they will somehow come now after 3 years and 4 years.
My lord, earlier also, one
We'll clarify that the judgment was given in the case of Mr. Manoranjan Mishra.
My lord, will your lordship post it day after tomorrow or tomorrow so that I will get back to your lordship?
No. This is a fact, sir.
I don't think.
Your only limited grievance is that persons similarly placed as Manoranjan Mishra may at some future point in time file a petition saying, now treat us as if we retired only at 60 and give us arrears of pay. Correct?
Right.
We are now denying, just listen to this, sir. We are already denying Mr. Mishra any arrear of pay.
My lord.
His appeal is going to be dismissed.
My lord.
Once we clarify that for work not done, you will not get paid. How can somebody who comes in future say, give me arrears of pay? They've not worked beyond 58.
Well, this is some order, it doesn't come under order 47 rule 1. I understand your lordship.
You've already, see, factually the position has changed, sir. The retirement age has become 60 in your organization.
But at the relevant time, my lord,
You have accepted that fact, sir. And we are not giving arrears of pay.
all right, I leave it to your lordship. Because
You see,
your lordship may confine it to this case only, my lord, and it should not be.
you just listen to the order, sir. All right. You see, there are 2 appeals filed against the order dated 19th June 2019, passed by the learned single judge, allowing review petition number 139 of 2017, filed by Sri Manoranjan Mishra, bracket, the appellant in writ appeal number 284 of 2009, against Orissa Computer Application Center, bracket OCAC, bracket, which admittedly is a government body, is a 100% government body owned by the government of Orissa, bracket, appellant in writ appeal number 306 of 2019.
No, it is a registered society, my lord.
All right, a registered society, which is a state government body.
So under the Society Registration Act, my lord.
That's right, sir. But you are,
And it has got its own finance and other things. It only receives a fixed grant of aid from the state government.
all right, which is a body that receives grant and aid from the government of Orissa. Full stop. Paragraph. The bone of contention before the learned single judge was regarding the retirement age of employees of OCAC. Full stop. While Sri Mishra was contending that the retirement age should be 60 years on par with all other state government servants, OCAC was resisting the plea on the ground that it was a registered society, an autonomous body, governed by its own set of regulations. Paragraph. Initially, by the judgment 15th May 2017, the learned single judge dismissed writ petition civil 14962 of 2016, filed by Sri Mishra. Full stop. However, on gathering more facts, Sri Mishra filed the aforementioned review petition number 139 of 2017, in which he was able to demonstrate that for all other public sector undertakings, bracket PSUs, bracket of the state government, the retirement age had already been increased to 60. Full stop. In the impugned order dated 19 June 2019, allowing Sri Mishra's review petition number 139 of 2017, the learned single judge has noted the above fact that employees of the Cuttack Development Authority, the Orissa, what is Oreda?
Oreda is
Renewable energy. Renewable energy, my lord.
Orissa Renewal
Agency, renewal agency, development, some agency. Renewable Orissa Renewable
Energy Development.
Development.
Orissa Renewable Energy Development Agency.
My lord, may I disturb your lordship for a moment, my lord?
And other public sector undertakings and public sector enterprises, though not PSUs, have been extended the benefit of enhancing the age of superannuation from 58 to 60 years. Full stop. The learned single judge was of the view that OCAC, being a state instrumentality, has to be likewise extended the same benefit. Full stop. On this basis, the learned single judge has, by the impugned order, reviewed the earlier order dated 15th May 2017, and in the operative portion stated that if Shri Mishra had in the meantime attained the age of 60 years, open quotation, he shall not be entitled to arrears of salary, full stop. However, he shall be deemed to be continuing in service up to the age of 60 years, and accordingly his pay shall be fixed by OCAC and refixed retirement benefit like pension, gratuity, etc. Full stop. Unquote. Paragraph. As far as OCAC's, full stop. The situation on the ground that has changed in the meanwhile is that all employees of OCAC are at present retiring at the age of 60 years and not 58 years. Full stop. The grievance of Shri Mishra against the impugned judgment is that he has been denied arrears of salary for the period between his actual date of retirement at 58 years and the enhanced age of retirement of 60 years. Paragraph. As far as OCAC is concerned, it is apprehended that others like Shri Mishra, who may have retired at 58 years, would now start claiming the refixation of their pension, gratuity, and recalculation of the retirement benefits on the basis of the impugned judgment of the learned single judge. Paragraph. As far as Shri Mishra's plea is concerned, it is untenable for the simple reason that he did not actually work for the period for which he is claiming arrears of salary. Full stop. The court is therefore not inclined to entertain his plea. Paragraph. As far as the apprehension expressed by OCAC in its appeal is concerned, the court clarifies that since only Shri Mishra came to the court with a writ petition, the judgment, the impugned order insofar as recalculation of his pension, gratuity, and other retirement benefits would be peculiar to the facts of his case and would not ipso facto result in OCAC having to extend the same benefit to others who may be similarly placed as Shri Mishra. Full stop. If such employees now come forward to make any similar claims, it will have to be decided on the individual facts of those cases. Full stop.
Milord, may I disturb your lordship for a minute, Milord? That Orissa Renewable Development Energy Development Authority, Milord, that they have not enjoying the 60 years, Milord, because there was a subsequent judgment to our decision of the writ application that they are entitled to retire at the age of 60, which has been stayed by your lordships. I have given that judgment.
All right, you remove, okay, OREDA you can remove. Remove that OREDA from that. All right.
That is as page 285.
All right. With the above clarification, the court is not inclined to entertain either of these writ appeals and they are dismissed as such. All right.
Obliged.
Item number 6.
6 not pressed, my lord. Item 6 not pressed.
Not pressed, dismissed as not pressed. All right.
Item number 7.
Item 7, my lord, on behalf of Mr. P.K. Das, praying for as he is unwell.
Mr. Das, and counsel for the appellant is stated to be unwell. Mr. 3rd April.
Item number 8.
May it please your lordship. The petitioner owns a shop. It was insured with the insurer against theft and burglary, etc. There was a burglary. He reported it. The claim was repudiated. Then he approached this honorable court. This honorable court dismissed the writ petition solely on the ground that the petition not the shop which was insured, and the proprietor had approached this honorable.
Yes, who's Jogendra Kumar Rai?
He is the proprietor.
No, but what does the cost title say?
Cost title is Jogendra Kumar Rai. They have
No, you have to show that you are the proprietor of that.
that I have written.
That's not good enough, sir. Please. You have to be serious about these things. You're so casual. That's the whole problem. You should have amended your cost title. You should have actually said as in capacity as proprietor.
They have communicated with me as Jogendra Kumar Rai.
No. You see, this appeal is directed against the judgment dated 5th
Then
August
your lordship may allow me
to withdraw.
to withdraw and file press.
Whatever, that is up to you, sir.
No, my lord.
Counsel for the appeal.
Your lordship now said that I could have amended. My lord, they have corresponded with me only as Jogendra Kumar Rai. I am the proprietor. And the shop could not have been a petitioner.
All right.
The insured was the shop and against burglary, but the shop could not have applied for.
Yeah, you say this present appeal is directed against the impugned order dated 5th August 2019 passed by the learned single judge, dismissing the appellant's OJC number 1274 of 2002, paragraph. The prayer in the said petition was for a direction to the respondent number 1, Oriental Insurance Company Limited, to settle the claim of the to pay the claim of rupees 7,60,000 made by the petitioner pursuant to the burglary committed in the business premises of the petition of the appellant on the basis of an insurance policy which was enclosed to the petition. Paragraph. The admitted position is what was insured was the proprietary concern of Messrs. Menaka Bhandar, and therefore the claimant legitimately had to be Messrs. Menaka Bhandar, proprietary concern, full stop. Counsel of the appellant submits that the appellant is in fact the sole proprietor of Messrs. Menaka Bhandar, and that the insurance company has throughout been corresponding with him in that capacity. Paragraph. If that be the position, then the appellant ought to have taken the care to amend the cost title in the writ petition to reflect the appellant to be Messrs. Menaka Bhandar, proprietary concern through its sole proprietor, which is the appellant. Full stop. However, the appellant failed to do so. Paragraph. In matters of this nature, it is very necessary. It is essential that the correct party is the claimant, and it is that party which then prefers the writ petition if the claim is not honored by respondent number 1, insurance company. Full stop. This is not a casual matter where, despite defective description of the claimant in the cost title, the learned single judge should be expected to grant relief to the wrong party. Paragraph. Consequently, the court is unable to find any error having been committed by the learned single judge in the impugned order. The appeal is accordingly dismissed.
Item number 9.
My lords, I am sorry, I am in the VC. Your lordship, I beg to have a new date, your lordship. I have to prepare a note, your lordship, for this case.
All right. Mr. Narendra Mishra and senior counsel.
I am for the respondent one.
All right. Both of you can prepare notes.
Yes.
As well as Mr. Yashavan Dash and senior counsel appearing for the respondent state that they will be submitting the respective notes of written arguments by the next date.
Right.
List on 16th March.
Definitely.
In fact, sad case is he's a cancer survivor.
Oh, I see. All right.
Item number 10.
Interim order to continue, your lordship.
Interim order to continue.
My lord, item number 10 may taken up next week. Some defect pointed out by the SR, so it can removal of defect.
Mr. Niranjan Pada, counsel for the appellant, undertakes to remove the defect before the next date.
May I just state that interim order really is contempt where personal appearance is given, my lord. That can be dispensed with till then, my lord. Why should there's no interim order really, technically speaking.
Whatever that is, let it cut.
All right.
Supplementary list, fresh admission, item 11.
May I please, your lordship? Lordship, in this matter, Justice Raman was
I
a
see.
part
List
of-
before a bench of which Justice Raman is not a member on 3rd April.
Item number 12.
Yes, my lord. My lord, today morning, I myself received the file as because Railway Department already merged
All right. At the request of counsel for the appellant, list on 3rd April. All right.
Item number 13. State of the question of law is at page 20. 1. Whether on the facts and in the circumstances of the case, the Odisha Sales Tax Tribunal traversed its jurisdiction by deleting penalty imposed under section 42(5) of the Odisha Value Added Tax 2004 on the face of the fact on record that there was no payment of admitted tax. This question has been answered by my lord's order in Chandrakant Jayantilan 42(5) penalty.
Answered in your favor or against you?
In favor of revenue.
Just simply say notice returnable 3rd April. All right.
Item 14.
My lords, no instruction.
No instruction.
With liberty.
Dismissed. All right.
Item number 15.
My lordship, no instruction with liberty.
No liberty, sir. No instructions dismissed. All right.
Item number 16. Dates appeal, my lord.
Revision, sir, not appeal. Audit visit report. This is now answered.
My lord, state appeal question of law is at page 17.
Audit visit report.
Yes, my lord.
It was already answered against you.
My lord. No, that is another point of question is there regarding question number 2.
Question number
2. 1, Roman 2. As page 18, at page 18, my
hire oblique lease.
Yes. Whether on the facts and in the circumstances of the case, the Odisha Sales Tax is justified in law in holding that there was no transfer of right to use as comprehended in the definition of sale contained in section 2, subsection 45, clause 40 of the Odisha Value Added Tax 2004 in the giving machineries in the higher end leases. My lord, as per audit visit report, page 26, my lord. From the top. Verified of the audited balance sheet, it was marked that the dealer has received machine hire charges.
All right. List before a bench of which Justice Raman is not a member on 4th April.
Item 17.
This is an audit assessment under section 42 of the Orissa Value Added Tax for the period 1/11/2005 to 31st December 2018. I have challenged the order passed by the chairman of the Orissa Sales Tax Tribunal.
Yes, ma'am.
Shreyans. This is that Shreyans case, sir.
Sir.
Refer to larger bench of Supreme Court. All right. Since the issue involved in the present case is now pending before a larger bench of the Supreme Court to reconsider the decision in State of Punjab versus Shreyans Industries Limited, 2016-91 VST 23(SC). The present revision petition is adjourned sine die awaiting the judgment of the larger bench of the Supreme Court. Liberty to parties to mention for listing thereafter.
Item number 18.
Item, may I please receive? And in this case, the department has come up with the appeal, my lord, challenging the order of the law tribunal on the ground that reassessment proceeding, my lord, was initiated. My lord, basing on the law tribunal has dismissed the case of the department on the ground that there was the material with the assessing officer, and subsequently, my lord, basing on the report of the Auditor General, my lord, that has been reopened. Only on this ground has been reopened. This
This is not a valid ground for opening, sir, reopening. That's settled law now. Mere audit report is not a ground for reopening.
this ground, my lord, this is the one.
All right. You say the challenge by the revenue in the present appeal against the order dated 19 March 2018 of the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, bracket IT80, allowing ITA number 300/CTK/2014, filed by the respondent SSC for the assessment year 2009-10. Seeks to urge the question whether the IT80 was right in accepting the plea of the respondent that the reopening of the assessment for the aforementioned AY only on the basis of absence of any new tangible material was sustainable in law. Paragraph. The factual position is that the assessing officer initiated reassessment proceedings. Only on the basis of a tax audit report and financial statements, which were already before the AO in the scrutiny proceedings under section 143 bracket 3 of the Act. Paragraph. This being the settled position of law that reopening of an assessment cannot be based on the same materials already available before the AO in the original assessment proceedings, the court sees no substantial question of law arising from the impugned order of the IT80. The appeal is accordingly dismissed.
Item number 19.
Made prisoner.
Are they receiving treatment, sir?
My lord, no treatment till date, man.
Oh,
We were called as per the direction of the, my lord, we were called. Our report was prepared and we are allowed to leave, and nothing has been done till date.
why is that,
Not
sir?
even single
I'm
test.
just clarifying, my lord. I think
My lord, before we will clarify, let me draw my lord's attention to my lord's order first, my lord. Order dated 16/9/2022. Wherein my lord was pleased to direct, a direction is hereby issued to AIMS Bhubaneswar to provide treatment to the 15 children whose names are set out in the writ petition, and cost of such treatment shall be reimbursed by the Government of India in the Department of Health and Family Welfare. A direction is issued to the Director, AIMS Bhubaneswar, to draw up a schedule for consultation of the said 15 children suffering from DFD with specialist in AIMS Bhubaneswar for the purpose of receiving A1 therapy in time-bound manner. This is done in consultation with Mr. Padhi, and ASGI, as well as Mr. Dhal, so and so, for the petitioner, and affidavit of compliance be placed before this court on the next date. But let me see the affidavit which has been filed by my lord in print. Affidavit dated 9/11/2022. Internal page 4, my lord, me see. This is really shocking, my lord. I should say, my lord, to what they have said. As resources are limited, my lord, with third line, internal page 4 of the counter which they have filed on 11/2022.
1 minute. Yes.
Third line, my lord, may see.
As resources are limited.
As resources are limited and have multiple uses, the policy makers have to make choice of prioritizing certain sets of interventions over others. The appropriate choice is then to support those interventions.
No, but now they have to just implement the order.
They
This
have
is
not
not an
done anything.
argument now.
Not done anything, well.
This is an argument prior to a direction.
Yes, my lord.
Once our direction is
my
issued,
lord's
to comply.
director. I'm just like.
A question, simple question, my lord. Is this the public policy, my lord? Is
Yes.
this the
Everything is
mandate?
Senior reading it. We have gone through he's reading the only paragraph. We have described everything. And we have stated in the specifically, we have stated that my lord, the 8 hospitals list has been given. Who are the hospitals? 8 AIMS hospital. These hospitals have a facility giving the treatment to those type of patients. It is not that all over India the 30 AIMS is there. All hospitals have that expectation. So initially, suppose a patient is coming. I am personally talking to the AIMS director. He told me that my lord, suppose any patient is coming. He has identified that he is suffering such and such. We cannot refuse to go without giving treatment. You go that of AIMS Delhi or Lucknow, Sanjay Gandhi. We can't say this. Immediately, initially they have treated it and they are referring the patient to the hospital. He has chosen out of 8 list, which hospital is suitable to him. Accordingly, he will go there. Whatever best treatment is required to given, he is given. The list is given, my lord. 8 hospitals,
No. What is available in those hospitals which is not available here?
Well, here is a case. What my learned friend has earlier cited to this, give the drugs, all these things. It is under the research. In US, that drugs has been under the investigation stage. It has not come to the final decision unless until it was not accepted by the international level. And this drugs also accepted by the government of India. That cannot be given to any patient.
Where have we said all that?
Yes, we have stated, my lord. Lordship may come to the paragraph 26, page internal 25 of the affidavit 911, my lord.
All right, let's see that.
Where is that?
Sorry, my lord. 26 by 27, yes.
Yes, sir.
So do you have the list of which hospitals they?
That is, my lord, that is page 22.
So you are prepared to give 50 lakhs per patient?
Yes. It was recent amendment is coming. Accordingly, we can spend it.
Is coming.
All right.
Yes.
So if you go, if they go there, you will undertake.
See the notification, page 74. That is a notification dated 19/5/2022. This office memorandum dated 19/5/2022. Let's have got it, man. In that, we have, may I read, my lord?
No. Where are they supposed to go? Sir, in respect of each of these 15 children,
my lord,
have you given nothing in writing that please go to this hospital?
No, nothing is there, my lord.
1 minute, sir. I'm asking him a question. If you start answering, sir, then
sorry,
what is left?
Lordship, come to the page 70. Page 70, the list of hospitals are there.
No. Please understand the question, Mr. Padi.
My lord.
15 children came to you.
My lord.
They consulted you. Did you give an advice in writing that please go to this hospital? We undertake to pay 50 lakhs for your treatment. Have you said that?
No, in that way, I will not say that.
So why not?
My lord,
you say it in an affidavit, you don't tell them.
My lord, I'm just clarifying. My lord, suppose a patient is coming. We are giving the initial treatment. Thereafter, we give option. These are the hospital.
No, I don't even know. I don't even know what initial treatment you gave each of these children, what advice you gave them. Unless you give it in writing, how will they know what is the advice given to them?
Yes.
So now again, you have to fix up a schedule for them to come and meet you. When each child came and met you,
I got
your
the
doctor
point.
did not keep notes.
The point, my lord. And now I got it.
You don't keep notes. Every doctor, even the smallest, the physician keeps notes of consultation. When somebody comes, even you go to your doctor, the doctor starts writing the prescription, what your the problem was.
Entry and all these things, but about his prescription.
No, what advice given? In fact, every doctor writes in the prescription, referred to such and such place.
Yes. In their prescription,
where are the notes of your consultation with these children?
Exactly. Yes.
You say an affidavit has been filed.
By the Minister of Health and Family.
by the Undersecretary to the Government of India, Ministry of Health and Family Welfare, on which is the date of this affidavit?
In 9, that is
9/11/2000.
On 9th November 2022, where inter alia, it is sought to be suggested that patients suffering from rare diseases like DMD, right?
Valid.
Have to approach the nearest single quotes center of excellence, unquote, COE, from where they can expect to get treatment. Stop. It is stated that as far as AIIMS Bhubaneswar is concerned, it is not a COE. But wherever it makes a recommendation for a patient visiting it to get treatment with the nearest available COE, under the extant policy, Bhubaneswar can provide financial assistance up to a maximum of rupees 50 lakhs per patient. Full stop. In para 30 of the affidavit, it is mentioned that AIIMS New Delhi had submitted a proposal for 22 persons suffering from rare diseases, and that the Government of India, in accordance with the policy, had released an amount of around rupees 11 crores to AIIMS New Delhi. Full stop. It is further stated, open quotation, similarly, all the cases where the COE had requested for requisition, while the answering respondent is in the process of releasing the financial assistance of maximum up to rupees 50 lakhs per patient for their treatment to the respective COEs, where such patients of rare diseases are being treated. Full stop, unquote. Mr. Padi on instruction states that while AIIMS Bhubaneswar is not in a position to provide the treatment, and particularly since the treatment requested, that is AON, is under clinical trial in India and not approved yet by the DCGI, each of the 15 children, 15 plus 1, no, 16 children.
15 man.
No. In the accompanying petition, there's one more.
16 man.
Each of the 16.
Another person.
Yeah. Each of the 16 children who have been referred to it by this court are being advised to receive treatment in other AIIMS elsewhere, which are declared as COEs. Full stop. Paragraph, when the court posed a question to Mr. Padi, learned DSGI, whether there was written instructions issued in respect of each of the 16 children, he undertook to now issue those written advices to each of them to enable them to not only receive the financial assistance spoken of, but also the treatment at the respective COEs to which they will be referred. Paragraph, for the above purpose, the 16 children will again be given specific dates on which they can visit AIIMS Bhubaneswar, receive the necessary advice and minimal treatment, advice and the requisite treatment, and requisite treatment and written advice. Full stop. This exercise be completed within the next 10 days. Full stop. Affidavit of compliance enclosing copies of the written advice provided to each of the 16 children be enclosed with such affidavit. Full stop. List on.
Seven.
We'll have it on 21st December. 19th December. 19th.
Valid.
December.
Item number 20.
Along with me, Ms. Bhavita is appearing.
All right.
Item 20.
None appears dismissed.
Item 21.
None appears dismissed.
Item number 22.
This is not a matter where initially this petitioner has approached your lordship in tax revision case bills and move it again. And your lordship was pleased to dispose of this application by order dated 16/2/2017 by Annexure 5 at page 45 minutes. And while disposing of the tax revision application, your lordship wills have directed that so far as the loading of goods from Haladia port, there are two ports from where the petitioner has loaded the goods. One from Haladia port, other from Paradip port. And referring to the investigation report of the investigating officer wills, your lordship directed that the transactions relating to loading of goods from Haladia port in the West Bengal, those are treated as interstate transactions, and the goods which are loaded from Paradip will be treated as intrastate transactions. And the assessing officers are accordingly redo assessment and recompute the liability minutes. Then matter went to the assessing officer on Annexure 6. Some clarification to the order also your lordship subsequently passed because the tax revision pertains to 2000 minutes 456. And the assessing officer wanted to redo assessment for 2 periods, 5, 6, 6, 7. And your lordship clarified by further direction at page 48 that the assessment should be confined to 5, 6, not 2. So that is now the assessing officer confined to 5, 6 by Annexure 6 and page 50 minutes. Your lordship will find the assessment culminated in refund of rupees 22,35,992. That being the excess of central sales tax paid by the petitioner. But even though there are two transactions as I submitted for lordship, one is the interstate. The interstate transactions could have been similarly in the way the assessing officer has done under Central Sales Tax Act under section rule 12(4) of the CST Odisha rules. The assessment would have been done under 43 of the Orissa Sales Value Added Tax Act. But without doing so, now the assessing officer has initiated two proceedings. Section 14. Section 49(2) says below, if pursuant to order passed by High Court or any tribunal or any other court, any order is passed within a period of 5 years without being affected by any provision of limitation available under law, the assessing officer can reassess the petitioner if the liability determined under the act, not under the act under which it should have been assessed. That is the purported precise scope of section 49(2). And 49(2) again goes back to the direction given by your lordship, which is the genesis, that is the section 80, this revision petition, which all we file for lordship is within the scope of section 80 of the Value Added Tax Act. And your lordship having passed certain specific direction, treating the goods loaded from Paradip port to intrastate sales, means the transaction under the Orissa Value Added Tax Act, that he should have confined to that. But assessing officer, without making 43 assessment, first did assessment under 49(2), 1. 2, while doing so, charged 53 lakhs from or towards interest under 34(1) of the Orissa Value Added Tax Act. That is the main subject matter of controversy here.
No. So, same question, sir. Against this order, there's an appeal. This is an assessment order.
Yes, assessment order. But as my lords know, this is unlike other assessment. Here, the assessment can be strictly confined to the direction of your lordship. He cannot diverge from
whatever. But you can take it in appeal. All these grounds are available to you in appeal.
But
there is a stay. We can continue a stay subject to you paying the admitted amount. According to refund is 22 lakhs.
No, that amount belongs your lordship directed that this amount will be adjusted against the liability, if any, under the Orissa Value Added Tax Act.
Correct.
That your lordship have said.
This is entry tax, is it?
This is VAT.
VAT only. VAT only.
Now the question is, when your lordship directed to assess in a particular manner, can the assessing officer now...
So that the appellate authority will examine that, sir.
Because that will amount to
Correct. So the same will continue. Can be adjusted for pre-deposit also. You already paid 49 lakhs.
That can be adjusted. But the only thing is that what I am a little scared of telling you, Lordship, my lords, that will almost amount to the appellate authority, my lords, examining your Lordship's order.
No. Only whether it has been done in accordance with our order. They won't be sitting in appeal over our order. You see, it is seen that the impugned order dated 22nd.
Even payment details, that's 49 lakhs, somewhat I have complied with.
The impugned order dated 20th March 2017 passed by the assessing officer is an appealable one. Under 9(2) of the OVAT Act is an appealable one. So with that view of the matter, while permitting the petitioner to avail of the appellate remedy in accordance with law, this court declines to interfere at this stage. Full stop. It is clarified that the amount of rupees 49.
Lordship, I may say 22 lakhs. That will suffice because the amount is so. Even 22 lakhs will also do. I have paid 26 lakhs, 16,848 by cash.
Oh,
and 20 adjustment.
You say it is seen that pursuant to the order dated 16th May to interim order dated 16th May 2017 passed by the court, the petitioner has paid rupees 26,16,848 and 23,15,327 was to be adjusted by the department against the tax demand. Paragraph. In that view of the matter, while directing the court directs that if the appeal is filed not later than 2nd January 2023, accompanied by an application for condonation of delay, explain the delay on account of the pendency of the present petition, the appellate authority will examine such application on its merits. Full stop. The interim order passed by this court on 16th May 2017 is directed to continue during the pendency of the appeal, which, if filed within the time indicated, should be disposed of by the appellate authority as expeditiously as possible and preferably within a period of 6 months from the said date.
Original order may kindly return.
The original of Annexure 10 be returned to the petitioner subject to being substituted with an attested photocopy thereof.
Obligation.
When petition is disposed of.
Item 23.
Item 23.
Oh, sorry.
No, it's, I have instructed. The Lordship may permit me, item 23 minutes. The Lordship may permit me to file a wakalat on behalf of the petitioner minutes.
Oh, I see. All right.
And this
Mr. Karar tenders a wakalat number on behalf of the petitioner. His name be now indicated in the cause list for the petitioner.
And similar, this relates to the levy of interest on entry tax law after the Honorable Supreme Court's judgment.
So it all is coming up on
16th of December.
All right. List on 16th December.
May I just humbly
I may be permitted to submit my lord. Our name may be deleted, my lord.
Yeah. And therefore the name of S. Das will be deleted. And
initially Justice Narsingh was appearing in this case. So
I see.
So the interim order dated 13/6/2017 may kindly be continued.
Interim order to continue.
And I have paid the entire tax amount in 2017.
Okay.
Item note 24.
I'm appearing for the petitioner, my lord. And I'm appearing for the petitioner, my lord.
Yes.
With your lordship's kind leave, I'd like to commence. The issue in contention here pertains to a shipping bill of export which the assessee had filed. Now, the assessee has requested an amendment of that shipping bill, which has so far not been allowed to them. No reasons have been given by the department. Several letters have been written to them. The amendment involves the declaration accompanying the shipping bill, which is that in the assessee's case, they originally declared that the goods were exported on the basis.
So we'll issue notice, sir. We'll just issue notice. Notice.
But I am appearing for the opposite parties.
All right. He accepts notice. Replies be filed within 8 weeks. Rejoined for the next.
My name may kindly be recorded.
All right.
For all the opposite.
Okay. Mr. A.K. Panda. PK.
Lords, I am appearing along with Mr. Anup Chakravarti. Peace out.
All right. List on 4th April. Right.
Very grateful.
Grateful.
Item 25.
On behalf of Mr. Guru, my lord, item number 25, 26, 27, and 83 infructuous, my lord.
Infructuous dismissed. All right. 25, 26, 27, and 83.
Item 28.
May I please? I have rectified the defects. Only the 13 days delay. The matter is similar matter is posted for 23rd March.
All right. List on 23rd March 23. All right.
Item 29.
Obliged.
It's a state appeal, 46 days delay. And the question of law is that page 20. Question B. Whether on the facts and in the circumstances of the case, the provision of Rule 43 of the Odisha Value Added Tax Rules 2005 is
Isn't this settled now? It's not settled by our judgments.
Somewhat.
This is MCAS. Which one is this? This is value added tax.
Upon the audit visit, it cannot reopen.
Tech mass residence.
Entry tax. No, this is
entry tax, and then
no, that is 3943.
Yes, sir.
Yes, sir.
Yes, sir.
All right. The questions start to be urged by the Revenue Department in the present revision petition, arising from the order dated 10th January 2014 of the Sales Tax, Odisha Sales Tax Tribunal, in essay number 46 bracket 5 of 2009-10 for the period 1/4/2007 to 31/10/2007 stands answered against the revenue against the department by the decision in case of automobiles versus Deputy Commissioner. Further, the tax amount is insignificant. Consequently, the court is not inclined to frame the questions, admit the present petition and frame the questions as urged. The petition is dismissed. The delay is condoned.
Item number 30.
My lords, may I please, my lords. My lords, the CMAPL for restoration, my lords, there is delay of 103 days. My lords, I have filed application for condonation of delay. But the previous lawyer said some problem. His wife was hospitalized and the cause of action survives. That is why, my lords.
Lift the balance quantity, which is the metric ton, when lease must have been over long ago, sir.
My lords, exactly same parties, my lords. This what happens, my lords? OMC sells us the ore, my lords. The department issues transit permit, my lords. They issue transit permit for 30 days. By the time we get the permit, only 2 days is left, my lords. That is why.
When did the lease get over?
My lords, exactly same party, similar case. This honorable court directed to lift within 2 months, my lords. Your lordship.
No, but this is iron ore, is it?
My lords.
What is the mineral? Iron ore.
Oh, yes, my lords.
When did the lease get over?
My lords, the period of lifting was 90 days, my lords.
Sir, date, sir. Which date?
My lords, it is. It is, my lords, long ago in 2000.
Valid until 31/12/2011.
After 11 years. After 11 years to permit you to lift stocks of iron ore, please. There's a limit to when you come to the court, when you ask for relief.
My lords, it was filed on 2013, my lords. It is a huge amount is involved, my lords. Lordship may.
You see, that just shows how serious you are.
My lords, I have mentioned.
Twice. Even in the EP law 911, it shows that you did not appear on 711.
My lords, your lordship will not believe. I have mentioned 10 times and bench was constituted because it was by the time one judge was retired, my lords. There was a.
The record says something else.
My lords.
The record says the matter was listed on 7th November 2014. Nobody appeared.
My lords.
Then on 19th November, again nobody appeared.
But CMAPL,
CMAPL because you woke up. See, the problem is really this. When you should be alert, when you should be pursuing the matter, you do not pursue it.
My lords,
Off into a slumber, then court has to somehow come to your rescue.
my lords, what I humbly submit when I
And
appeared,
even CMAPL is delayed. Sir, the amazing thing is CMAPL is delayed by 100 days. So which just shows how serious you are.
Your lordship is here in merits, my lords.
No.
Just
I know. And they didn't lift. Yeah. You say the court is not satisfied at all with the explanation for the delay in filing the CMAPL, which is 103 days. Consequently, the application for delay is dismissed.
my lords,
Consequently, the CMAPL is dismissed.
liberty may be given to realize in common law forum, my lords.
All right.
Item 31.
May I please, my lord? This case also covered by the case of automobiles as well as the full bench ECMAS regime. Here the question is that there is no assessment under 39 of the
All right. The
My
following
lord,
revision.
Page 4 of the revision petition, para 7.2. The petitioner had filed a returns within the prescribed period from 1/4/2010 to 31/3/2011. And self-assessment was made under section 39(2) of the VAT Act. It is his submission.
Yeah, but there's no communication of self-assessment. Yeah.
That has to be.
There's no communication. You say the admit the following question is framed for consideration. Just take question 2. The above question now stands answered in favor of the SSC and against the department by the judgment of this court in case of automobiles.
My lord, I have to verify the records.
And the order sheet is annexed at page 92 to 93, my lord, annexure 5.
Yeah. The order sheet, which is at annexure 5, reveals that there was no communication to the petitioner of the acceptance of self-assessment. Full stop. In that view of the matter, the question is answered in favor of the SSC and against the department. The impugn order of the tribunal. And the corresponding orders of the first appellate authority and AO are accordingly set aside. The revision petition is allowed in the above terms. No orders is to cause.
Item 32.
Your Lordship, there's a delay of 65 days.
All right. So many other defects.
Your Lordship, 1 week time may be granted to remove the defects.
Defects be removed within a week, list thereafter.
Item 33.
As a last chance, you see.
33.
33. My lords, the defect pointed out that the cost is not deposited, but a receipt is here. And I have
not filed, it says. I don't know. Receipt is there. All right. The receipt for payment of ₹500 has been shown to the court. Ask him to return it. It's all right. What's the matter about it?
My lords, TDS, your lordship kindly see at page 23. My lords, those TDS certificates, though produced, were not accounted for, my lords. That is a small question involved, my lords. Page 20.
What is the amount involved? Is some
my lords, the
76,000.
My lords, but there is, if it is accounted for, my lords, I am entitled to refund, my lords. My lords, this is by Government of India Railway Department, my lords. And
all right. You say notice returnable 5th April. All right.
Item 34.
None appears dismissed.
Item number 35.
Again, deficit could be not paid.
I'll comply with the defects. Your Lordship.
Last opportunity to cure the defects within a week, list thereafter. Right.
Item number 36.
None appears dismissed.
The defect pointed out that I had to give a certificate about the cartridge papers and good ground that I'll be doing it within a week.
All right. Defects be cured within a week as a last chance, list thereafter. Right.
Item number 37.
CMPL is within time, but dismissed on the ground of default.
They re-employed pensioner, my lord, a defense personnel, and they have recovered also 12,000 some odd rupees.
It's all right, sir. Why should we interfere?
And only question that my review application and original application having been dismissed, thereafter I have come to the Honorable High Court. And read.
What is the main matter about? Tell us that.
Main matter, my lord, while fixation, they are completely doing wrong. Give me a wrong figure that under this scope of this circular, you have to apply for fixation. But that is a wrong circular, subsequently admitted. But Land Tribunal did not take note of it. And it will have a cascading effect on his pension value. Now 72 years old, but this issue remains lively and survives. Re-employed defense personnel and 98 to 17, the case was not taken up. And on the date it was taken up, I have given a very fair and frank confession about the lawyer's ill health immediately in the court.
For the reason therein that order dated 10/8/2017 is recalled. OJC number 13562 of 1998 is restored to file. That OJC 13562, you say separate order, restored today by virtue of order passed and so on. List before the roster bench on 3rd January 2021.
Item 38.
38, my lord, there is defect, my lord. I'll remove the defect within a week, my lord.
Defects be removed within a week as per the last opportunity.
Next,
39.
Same,
man.
Item 40.
Well, the only short question is that registration will be granted from the date of application or from the date of order. The order will be passed on 31st.
It's not a covered matter.
No, it is not the 142006 registration is granted, but the petitioner claim is from the date of application.
Correct.
The only short question.
That's correct, police. You say the short question urged for consideration by the revenue in this appeal against an order dated 15/2/2011 passed by the ITAT Cuttack bench in ITA number 39/CTK/2010 filed by the respondent SSC is whether the date of registration under section 12 capital A of the Income Tax Act 1961 should be granted from the date of the order or from the date
of application.
Full stop. The above has been answered in favor of the SSC and against the department by the ITAT. Full stop. Having heard learned counsel of the parties and having perused the impugned order of the ITAT, it is seen that there were no reasons given by the Commissioner of Income Tax in not granting the registration with effect from the date of the application. Full stop. The court is unable to find any substantial question of law arising from the order of the ITAT. The appeal is accordingly dismissed.
Item number 41.
Item number 41, 42, and 43 may kindly be taken up with
item 9. Well, as the last item.
Additional supplementary.
But that will take it up before lunch.
Yes.
It is fixed at 2 p.m.
We're telling you we will not be taking it up at 2 p.m. We'll be taking it up before lunch. A notice has already been issued for that.
Item 44.
44 and 45, my lord, the defects will be removed by next week.
Defects be removed within a week list thereafter.
Item number 46.
None appears dismissed.
Item number 47.
Item number 47, I am appearing in virtual mode, your lordship. Your lordship, the state has to obtain instruction, your lordship.
All right. But defect is that prior representation not made.
Lordship, I have made through email, your lordship.
All right. At the request of counsel for the appellant, list on 4th January.
Item 46, my lords.
Item 46 was not called, my lord.
Yes, it was called. You are not there.
I was not. Sorry, my lord. Sorry, my lord, sir.
Your appearance.
Item 48.
On behalf of Mr. Piker, no instructions.
No instructions dispersed. All right.
Item number 49.
My lords, there is a defect. The certified copy of the tribunal's order not filed. Actually, I have filed a petition for dispensing with. This is a covered matter, my lords. I have given a note your lords must have seen. There are 7 appeals, out of which by the previous order of your lordship's court is the expedition. 1999, 2000, 2000, 2001, 2001-2, they have been disposed of and 4 are remaining. Whereas here, in this case, I am saying that the learned tribunal member, Mr. Saini, who was once the member of the accountant member and against this nature of cases, was overruled by a full bench, which ultimately went to the Supreme Court. And he was, unfortunately for us, so he said that the board is not entitled. Although from 86 ITR, we are entitled, and your lordship's judgment, which I have given your lordship, has allowed this, following the Rajasthan Granth case, have allowed this. And therefore,
there's another pending writ petition, is it? 4447 of 2008?
Yes.
That has been disposed of. I have given copies of
9th December.
And that record has come to your lordship also.
Correct. Let me just see it. Yeah.
I've given a detailed note also, lords.
Where is that?
That is in the 4447 of 2008.
So we allowed this in terms of that judgment, Mr.
Yes, Lord.
Yes.
All right.
Is filed an IA. Four two eight seven of 2020.
Yeah. First you say IA number 4287 of 2020. For the reason stated, the application is allowed. The amendments are sprayed for.
No, it's not an amendment. It's only. No, sorry, no, I have made an amendment also.
Right. And the amendments are sprayed for are allowed.
We have brought the judgment of your lordship's court into this case.
All right. You say 16422 of 2017 for the reason stated there, the application is allowed. As prayed for. Then in the main matter, you say it is not in dispute that the similar question is raised in the present petition. Stands answered in favor of the petition by the judgment dated 11 December 2019 of the division bench of this court in writ petition civil 4447 of 2008 bracket Board of Secondary Education versus the Chief Commissioner of Income Tax. Full stop. That judgment is attained finality with no appeal having been filed against it by the department. Full stop. Accordingly, annexures, accordingly, the order dated 18 January 2007 passed by the Chief Commissioner of Income Tax Orissa under section 10 bracket 23 capital C bracket Roman small 6 of the Income Tax 1961 for the financial years 2001 to 2 to 2003 to 4. The corresponding notices issued under section 148 of the income of the Act for AYs 99-2000 for assessment years, you say bracket AYs 99-2000, 2000, 2001, and 2001-2002.
Minus 99 to 2000. And three have been already allowed. in the earlier.
So what you've challenged here is 99, 2000, 2000, 2001, and 2001, 2002.
Yes.
And that is what we are quashing now, sir.
Okay.
And the corresponding demand notices for the said AUIs are hereby quashed. The writ petition is allowed in the above terms, no orders is to cause.
It is 2002, 3, 3, 4. All of them should be quashed.
So whatever is there in annexures 1, 2, and 3, that is your prayer clause.
Well,
we are quashing that.
okay.
Right.
Item number 50.
I may be granted refund, my lords. They have taken the money long back.
That you will apply separately for, sir. Now, as a result of this judgment, you will apply for refund. Right.
Okay.
Right.
My lords, item 50, there is some defects. I will remove within a week.
Defects be removed within a week list thereafter. Right.
Item 51.
May please, Lordship. My lord, here the present petitioner is a president of a school.
Some defect is there, sir.
My lord?
Defect.
So defect is some one page is not properly legible.
Could cure it, sir. Defects be cured within a week.
So within 2 days.
In any view of the matter, can I make a statement?
My lord, one thing may I submit.
He is an
now
objector.
The collector has recommended for shifting because 53(5) the exclusive power lies with the Lord and Commission of Excise. The matter is sub judice before the commissioner, my lord. Let both the parties be present, so matter can be decided there.
That's what I'm trying to bring to your lordship's notice. Kindly see.
Commissioner can take a decision.
Commissioner has already noticed to all the objectors fixing the date on 30th of November to hear all the objectors. So let him appear before the commissioner. Commissioner has noticed everyone.
So I may be permitted to put the relevant documents. Let's say that for adjudication.
You can do.
In respect to the same,
I'm appearing for the
IMFL on shop. The commissioner has fixed the date of hearing of the objections as 30th November 2022 at 11 a.m. Full stop. The memo submitted by opposite party number 5 to this effect is taken on record. Paragraph in that view of the matter, the petitioner is also permitted to appear before the commissioner with all documents in his possession.
Petitioner is already noticed.
He is on the set date before the commissioner. Full stop. No further relief can be granted at this stage in the present petition. It's disposed of. Right.
Item 52. Item number 52.
This is state of
this. They've been taking for a long time. Only now they've come. Yes. Yes, sir.
State revision. The question of law, we have filed a separate revised modified question of law on 13/11/2017.
But who's appearing for the, I think now the fresh notice will have to go. You say the revised modified question of law is taken on record. Fresh notice to the respondent returnable 4 January.
Item 53.
53 minus state revision.
What's the tax effect here?
That which is, my lord.
Advance ruling. Oh, I see. List before a bench of which Justice Raman is not a member. On 7th February.
Item 54.
54 one Passover matter.
Passover.
Item number 55.
My lords, you will kindly see on 20 January 2016, notice was issued and an interim measure stay was granted. It is squarely covered by the judgment of this honorable court in Indio Limited. Lords, you will kindly see an assessment for the period 98-99 was completed under Annexure 2 at page 26. Later on AG's objection, it was reopened. Annexure 3 at page 28. Lordship will kindly see.
No reason for reopening.
No reason. And the tribunal, most interesting part lies in the order of the tribunal, that is Annexure 5 at page 34. Lordship will be pleased to see. I'm just reading. 1 minute, my lords. Yes. Page
Emergence of new material, namely receipt of AG report.
Yes. My lords may be pleased to see page 37. The challenge, the learned counsel on behalf of the has relied on the decision rendered in Indio Limited versus Commission of Sales Tax in 148 STC page 61. But in Indio Limited, the judgment was that notice under section 12A was issued first and order in the order sheet was maintained thereafter. Full stop. In such situation, the Honorable Court held that the notice being mechanically issued, the same cannot be held to be tenable. Further, in that case, the petitioner challenged the notice under section 12A of the OST Act by way of writ petition. But in the instant case, the appellant dealer has already acted pursuant to notice and participate in the proceeding without any objection whatsoever. And therefore, the learned tribunal sustains the order of reassessment.
My lord, in India Limited, against this order, the state prefer SLP before.
That has been dismissed.
Yes, dismissed on facts.
By Sudarshan Reddy. Yes.
No, but here again, what are the reasons for reopening? Tell us.
The
Only audit report.
Yes, my lord. But the tribunals, after going through so many judicial pronouncements.
No. Indoor Limited says it merely audit report.
Yes, sole basis. There has to be some.
You have to form your opinion, sir.
Yes.
On the basis of the audit report, you have to record your opinion. That's what's Indoor Limited.
Yes, sir.
So same facts. Same facts. You say, admit the following question of law is framed for consideration. Take from only C. Yeah?
Only C.
End of page 17, top of page 18. Paragraph. Therefore, in the present case, it is seen that the assessing officer reopened the assessment for the period 1998-99 only on the basis of the audit report, without independently recording his opinion that there existed materials justifying reopening of the assessment. Paragraph. In identical circumstances, in the Enduro Limited versus Commission of Sales Tax, Manu OR 144/2006, this court quashed the reassessment order under section 12(8) of the Orissa Sales Tax Act 1947, bracket OST Act. Full stop. It may be mentioned here that the judgment of this court in the Enduro Limited Supra was affirmed by the Supreme Court dismissing the department's special petition against the said judgment. Paragraph. In the present case, the tribunal has in the impugned order dated 18/2/2014 in essay number 56 of 2007-08 filed by the SSC sought to distinguish the in the Enduro Limited Supra only on the basis that the SSC appeared pursuant to the notice issued under section 12(8) of the OST Act and participate in the proceedings. Full stop. That can hardly be the reason to distinguish the applicability of the aforementioned judgment. Full stop. The mere participation by the SSC pursuant to the notice under section 12(8) of the OST Act would not prevent the SSC from questioning the tenability of those proceedings on the grounds as raised in the Enduro Limited Supra. Paragraph. For the aforementioned reasons, the aforementioned questions are answered in favor of the SSC and against the department, and the impugned order of the Orissa Sales Tax Tribunal and the corresponding orders of the First Appellate Authority and assessing officer are hereby set aside. The revision petition is allowed in the above terms.
Item number 56.
Covered against you.
56. 56 man need some time to reconstitute the brief, my lord. Not receivable.
The question is already answered against you, sir. In favor of the revenue, sir. All right. Counsel to the revenue.
You are appearing for this.
Yes, my lord. I'm appearing for the dealer, opposite party.
This matter is covered by Bansapani. Have you seen that?
My lord.
2016.
My lord.
Should we allow the petition then?
Yes.
All right. You say admit the following question of law is framed for consideration. Just one, no? Question number 1. Yeah. Admittedly, the above question stands answered in favor of the revenue and against the department by the judgment of this court in Bansapani Traders. Iron and steel. Whatever that citation. Consequently, the question framed is answered in the affirmative, and the impugn order of the tribunal and the corresponding orders of the first appellate authority are hereby set aside. Right. The revision petition is disposed of.
Obliged.
Item number 57.
57, my lord, I pray any other bench, my lord. My lord, Justice Ramban is a party, my lord.
Oh.
Any other bench.
List before a bench of which Justice Raman is not a party.
Interim order to continue.
On 4th January, interim order to continue.
Obliged, my lord.
Item number 58.
My lord, due to the death of his father, Mr. Bahali is on accommodation. So the matter may be listed 2 weeks after, my lord.
All right. Mr. Bali stated to be in some personal difficulty. List for final hearing on. First March. At note 59. And what none appearing? None appears. The petition is dismissed. Item number 60.
Lordship, even though the answer is, the question is answered in favor of the assessee, in the case of Radhakeshav Rice Mill, Justice Raman was a part of the bench before the tribunal.
All right. Part of the bench? No, must have appeared.
Sorry.
But if it's covered by a judgment, then you can't have any objection.
Nalco review.
Then they won't have no objections.
Not Nalco.
All right. You see the
Para 10 and 11. Question number 1, Your Lordship.
Right. Admit the following question is framed.
It was admitted, Your Lordship.
Already admitted, is it?
Yes, Your Lordship.
You say by the order dated 17 August 2017, the following question was admitted, framed for consideration by this court. Reproduce the question. Paragraph. The said question now stands answered in favor of the assessee and against the department by the judgment dated 20th June 2022 in STREV 1099 of 2008, bracket Mrs. Radhakeshav Rice Mill Private Limited, in the state of Orissa. Accordingly, the impugned order of the tribunal is hereby set aside and the order of the first appellate authority is restored. The revision petition is allowed in the above terms. No orders is to pass. Item number 61.
Obliged to Lordship.
In page 5 of the writ application, I have mentioned previously I have moved before this honorable court, and this honorable court on 28/10/2021 directed to the Tahsildar to examine and pass necessary.
What happened to those affidavit for encroachment?
Yes, their counter page 4, second para, admitted again they have encroached.
No, 1 minute, sir. We passed an order on 21st September.
Yes.
You have to file an affidavit.
In the portion to that order also, no affidavit.
Last opportunity to the state to file an affidavit in terms of the order dated 21st September 2022. Before the next date.
I pray my lord, direct to the Tahsildar, they will complete the process within a short date.
That can be done. Your lordship can direct that.
Again, you will come back, sir. Nothing will happen. Then third writ petition will be filed.
Since 4/4/2022, Tahsildar has not taken any.
So if I pass the order today, he will not take any action. Within a year's time, you will be filing one more writ petition. That is your chance. If you want us to do that, we'll do.
Pass a time-bound order, I will ask the Tahsildar to comply it. Because there is no meaning in keeping this matter pending for last 10 years.
All right. Counsel petitioner states that he will be satisfied if a time-bound direction is issued to the Tahsildar. What's the area?
Baliapal.
Baliapal. If all the encroachment cases are disposed of in a time-bound manner. Paragraph. Accordingly, a direction is issued to opposite party number 3 to ensure that all encroachment cases already instituted are disposed of within a period of 6 months from.
Yes. The petitioner will be directed to produce this order.
Yeah, copy of this order be produced by the petitioner before the Tahsildar.
For necessary compliance.
For necessary compliance within a week. Full stop. No, be produced within a week before the Tahsildar for necessary compliance. Irrespective of that, a copy of the order be sent to the Tahsildar forthwith for compliance. The petition is disposed of in above terms. Right.
Item number 62.
May I please, your lordship, on behalf of Mr. K.K. Rao, pardon to mention, my lord, file is misplaced. Kindly allow us 2 weeks time to file rejoice.
Counsel for the petitioner is stated in some difficulty. 5th January.
Item number 63.
No, not 5th January. Sorry, sir. 7th January.
63.
No, 62 gala. 63.
Call 63. 27th is a Friday. All right. All right. 31st January.
Item number 63.
May I please, your lordship? Item number 63, sub-item 2, your lordship may kindly see order dated 17/3/2000.
Anyway, item 1, nobody is appearing.
Item 1, Mr. Potti.
None appears, that's dismissed. Item 2, what do we have to see?
Item 2, sub-item, your lordship may kindly see your order dated 17/3/2021. May I place this order? Lastly, it is submitted by the learned counsel for petitioner.
So the Jindal stainless was before the larger bench. That's over now? Or is it still before the larger bench?
It is February.
No, that 41/4. 41/4.
Yes, my lord. Ranks case is there.
7 days.
7 days. The building is covered by my lord's order. Pal construction.
Pal construction.
Right. Where is the judgment, sir? Pal construction.
I have no.
All right. All right. It was noticed by this court in its order dated 17 March 2021 that the issue concerning the mandatory requirement of Section 41 of the Orissa Value Added Tax 2004 that is assessment order being passed on the basis of an audit report, was before the larger bench of this court. Full stop. The larger bench has now delivered its judgment in dated -in answering the issue in the affirmative, namely that the non-compliance with the mandatory requirement of Section 41(4) of the OAT Act, that the audit visit report should be submitted to the assessing authority within 7 days from the date of the audit, would render the assessment non-est. Accordingly, the present case also, since the audit visit report was not submitted to the assessing authority within 7 days from the date of the visit of the audit team, the impugned assessment order dated 9/2006 and the corresponding orders of the November 2006 is hereby set aside. The writ petition is allowed in the above terms. No orders.
From 64. Item number 64.
May it please your lordships.
You are appearing for the petitioner now?
I am for the petitioner. I have filed my power, but
your name is not shown.
Yes, in the
name of Mr. S. Rai should be shown for the petitioner. The other names shown be deleted. Yes.
My lords may be pleased to see this writ petition was admitted on 16/8/2019. And as per the direction of this Honorable Court, I have paid rupees 1,69 lakhs. Now, my lords, even though it has been filed with effect from 2013, notice was issued in 24/11/2015, and thereafter it was admitted. No counter affidavit has been filed. So first thing is that because of non-traversal, the writ petition is to be allowed. Yes, my lords. And I am suffering, my lords.
Assessment order.
Huh?
Assessment order.
Assessment order. I cannot be relegated to the appellate authority after 4 years, after lapse of 10 years. Now it is 2023 is knocking at my door. Lordship, this question is, the petitioner is a Government of India corporation, my lords. It received DEPB, Duty Entitlement Passbook, as a lordship, as a my export, because of the export made, and in order to neutralize the import duty, this was given to me. Now, my lords, this
has to be finally heard, sir. Then,
beg your pardon?
This has to be finally heard. He will not be ready with all your powerful arguments. You're exploiting a weak moment. No counter affidavit, no instructions. You're going for the kill.
Now, my lords, it is already. I am beggar.
Counter to be filed.
Counter, why? At this time, have you filed any application for filing of counter?
Petition of the court.
You just produce a record, sir.
Yes. That will be better.
You say no counter affidavit has been filed for over 9 years. The department is directed to produce all the relevant records for the court on the next date. Interim order to continue. List for final hearing on 5th January.
5th January.
I learned a little bit more time.
No. My lord. I am
January.
All right.
Records to be brought from the
11 January. All right.
11 January, yes. Today he has escaped.
Item 65.
Lordship, kindly see my application at Annexure 2 in format 324 for the refund of excess input tax credit, and the notice was issued on 4/8/2016, and the department was directed to take instruction.
Now we'll give a time-bound directions. Let them dispose of your application.
Dispose of the Annexure 2, my lord, in accordance with 58(4)(a), my lord.
All right. The prayer in the present petition is for a mandamus to the opposite parties to grant refund of excess input tax credit in terms of the petitioner's application in Annexure 2. So the application itself is dated 30th April 2009. Full stop. despite notice having been issued in the present petition way back on 4th January 2016. For nearly 7 years now, there has been no reply filed by the department. Stop in that view of matter. A direction is issued to the department to process the petitioner's application, bracket annexure 2. And after hearing the petitioner, on a date to be intimated to the petitioner at least 10 days in advance, to pass orders on the said application, to pass appropriate reasoned order on the said application, not later than 2nd January 2023, and communicated to the petitioner within a week thereafter. Stop. The court clarifies it is not expressed anywhere in the matter. The petition is dismissed.
Item 66.
None appears dismissed.
Item number 67. Item 67.
None appears in the petition. Dismissed. Mr. Chimanka is for the respondent.
67.
Item 68.
The memo is taken on record. No instructions to
Made peace since 68. 68 I'm
the sub items.
I'm appearing in 68 there are 3 matters.
1 minute. Which is this memo that
7086?
In the first item you've got a memo.
In all the 3 items, I'm entering appearance just to apprise.
Ignore the memo. Sorry.
The company has undergone CIRP.
I see.
So I need to apprise that.
So you'll have to bring an amendment then. Mr. Shashwat Acharya, counsel for the petitioner enters appearance. His name now be shown in place of the earlier counsel in the cause list for the petitioner. Paragraph Mr. Acharya states that developments have to be brought on record. 68. He is permitted to file an affidavit / application before the next date.
I'll just place on affidavit what the subsequent events. Yeah, there's no need of amendment because
we have said affidavit / amendment. It's up to you, sir.
Very well.
21st February.
Great privilege.
67.
Item 69. 69.
Yes.
Shivakashi Enterprises.
Yes, madam. Here also, they have not controverted the pleadings. And notice was issued on 16/2/2017. Interim stay was granted, my lords. And even if after expiry of 6 years, they have not filed their controverting my allegations. This has to be allowed, my lords.
My lord, it has to be go back, my lord.
Huh?
Go back.
Go back. Yes. Set aside.
Go back to the assessing authority for redo the.
Yes. I am satisfied.
All right. You say the challenge in the present petition is to No. The direction prayed for in the present petition is for a mandamus to the department to allow the petitioner to revise his return. That's all.
Revise the return.
All right.
Yes. Let me revise my return. Yes.
No, but what the interim order is that audit notice is stayed.
Yes. Audit gave a notice, my lords. In that notice, I was in 2016 at page 28. I was asked to produce the books of accounts for the purpose of assessment. And I have given several requests annexed to. Lordship may kindly see I have requested to allow me to revise the return.
So then what is the purpose of sending back and all?
Yes. It is direction to.
I don't think you understood what the matter is about.
I misunderstood with other matters.
No counter at this stage.
It has not been admitted and nothing has been done.
No, admitted. Nothing has been done. You have not seen the record.
Yes.
Yes. 16/2/2017 ଦେଖନ୍ତୁ ଆଜ୍ଞା notice ହେଇଛି interim stay ହେଇଛି मो सर्टिफाइड कॉपी रखी आपको देबी explain. Oh,
It's okay. बाद में कर लेना.
पानी पड़ी गला.
No. Isn't there a time limit for filing a
Yes, my
revised
lord,
return?
33.5, my lord.
What is that?
5 is something different. After notice of audit, you cannot.
That is before the audit notice is received and before the audit has taken place, I am not allowed to file my revised return as per that year. Then your lordship will be pleased to see the explanation given under Annexure 2. I am manufacturing ash brick and which is exempted from VAT. Oh, sorry.
What is the legal position, sir? When should revised return? When can it be filed?
Yes, I am given my lords. Lordship will be pleased
Let
to
him
see.
let him examine it, sir. The short question that arises for consideration here is whether the petitioner can be allowed to file a revised return for the period 1st January 2015 to 30th September 2015, post an audit visit report, a notice having been issued under the OVAT Act. Question mark. Despite notice having been issued in the present petition way back on 16/2/2017, no reply has been filed till date by the department. By that, on that date, an order had been passed staying the audit notice dated 21st November 2016. Paragraph counsel of the department wants to examine the position and furnish a written note of arguments with advance copy to counsel of the petitioner.
Copy of which may be given to.
Yeah. Definitely. List on. So he can't know. Let's see if they come up with that. बाद में करना है, ये सब जल्दी नहीं है अभी, बाद में करना. You need that. 27th March.
Item number 70.
Interim order to continue.
Yeah, interim order to continue.
Item number 70.
70 side. Date is
Ex parte corrigendum order. what has been challenged is an ex parte cottage interim order. Here you filed a counter affidavit.
Yes.
Who's for the petitioner? None appears for the petitioner. Dismiss the interim order is vacated. All right.
Item 71.
May I please?
My lord, this honorable last 7/9/2017 had issued the notice to the opposite party to file the counter. Till date, no counter has filed. This assessment order has been challenged on the plea of it has been passed beyond the period of limitation on the 42(6). So no counter has been.
No counter is there, sir.
Counter is there, man.
Not solved on.
All right. Copy of the counter affidavit be served and constitute the petitioner within 3 days. Return to that if any be filed for the next date.
Take that.
Interim order continue. List on 8th March. Oh, sorry, 8th is a holiday. Sorry. 15th March.
Item 72.
May I please? Here, my lord, I have challenged the assessment on 3 grounds, my lord. One is, my lord, 39 order has not been passed. Second is with doctrine and impossibility. And third is violation of principle of natural justice. Counter has been filed. If your lordship permit, I can file a small rejoinder.
All right. Rejoinder will be filed next date. There's an interim order.
Yes, your lordship.
Interim order to continue. 21st March.
Item 73. Item number 73.
None appears dismissed.
Item number 74. Item 74.
Ms. Sahu? Mr. Sahu is there. Orissa Steel Doors.
Your lordship, kindly turn to Millers.
On the last occasion, my lord, Leonard Sini had filed the rejoinder. The reply to the rejoinder has been prepared. It will be filed today. I'm only praying, my lord. I'll serve the copy.
There is no end to this.
Yeah,
whatever is filed below the additional affidavit pursuant to your lordship direction, but its content will be based on record.
My lord,
RTI report is there.
Concern officer is on
Anyway, interim order is there in your favor.
Yes.
Interim order is there.
The concern officer is on his way from Bhubaneswar, my lord. Within half an hour, we'll be filing. In due course,
only I will pray your lordship bills. But the matter may taken up in the next week. I pray your lordship bills.
Yes, sir. Yes.
Otherwise, contingent liability, my lords knows I cannot take a loan if contingent liability were in my accounts. That is what is happening essentially.
Counsel appearing for the opposite parties states that he'll be filing a reply to the rejoinder filed by the petitioner within 3 days. It's made clear that there will be no further pleadings in the matter. Interim order to continue. List for hearing on 29th March. Right.
Sir, can it be a little earlier?
All right.
A small matter, because I will not take more than 5 to 10 minutes.
I know. But those 10 minutes are, we have to find it in the next 3 months.
Item 75.
Both the matters.
Both matters.
75.
On the last occasion, state has prayed for
6/11,
time for counter filing. Counter has not come, my lord.
8/4/2021.
So by the previous track record, it's too early to file counters. It's only a 2021 matter.
Yes. I agree, man.
Last opportunity to the department to file its reply within 8 weeks. Rejoinder for the next date. Is there an interim order?
Yes.
Interim order.
My lord sitting in November 2021 has stayed for stay of further proceedings.
Interim order to continue. List on 4th April.
4th April, my lords. Interim order to continue.
Item 76.
I'm sorry to make a small interruption. At 28th March, your lordship have adjourned many matters, my lords. Any other day, maybe
4th April.
No, at least during March, any day. Your lordship
4th April.
Any day, your lordship.
4th April. All right. Yeah. beyond financial. Yeah.
Item 76.
Well, that has been fixed on 28/11/2022. Let him appear and pay the amount.
The wrong ground. We have petitioners already filed affidavit for 1.17 crores how to pay, and voluntary pay 23 lakhs. They have not considered 23 lakhs unless it is so-called notice that hearing fixed. My prayer that the honorable court should direction to the OP number 5 to create a temporary ID for payment of tax so that he can suffering can be removed because out of this.
But they're giving you installments, sir.
The installment, okay.
But you appear before them. Then.
Installment they have not allowed so far.
No, but you have to appear. You have to convince them. You say a date has been fixed for the petitioner to appear before the assistant commissioner in regard to his plea for discharging the outstanding GST liability by way of installments. On 28 November 2022. Counsel petitioner states that the petitioner's managing partner will appear on the date fixed.
Let's see, the amount only paid 23 lakh, that was not indicated that.
No, whatever, and make all submissions, including the ones urged in the present petition. So, an appropriate order shall thereafter be passed by the assistant commissioner within a period of 2 weeks thereafter. 2 weeks thereafter, and communicate with the petitioner within a week thereafter. Paragraph. No further directions are called for in the present petition. The court clarifies it has not expressed any view in merits. The petition is disposed of. Right.
Item number 77.
Your Lordship, it's a very short point involved in this matter.
77, I pray pass over since Mr. Nanda, senior advocate, Mr.
May I just surprise your
has
Lordship?
been engaged in this
Short matter.
4 matters in this batch.
For whom has he been engaged?
In WPC number 18819 of 13.
No, for whom?
For the bits.
All of us are for petitioners.
Oh,
all are
That's what I'm saying, Lordship.
Before
Small
they
matter.
start-
Let me apprise your Lordships.
Before they start, if your Lordship will permit me, I will only make a simple statement before your Lordship. Your Lordship may kindly have a glance, Annexure 5 at page 65. The order of the Excise Commissioner under the old rule, this is under the old rule, not Odisha Excise Rules 65 rules. The Excise Commissioner passed an order that the transportation fee will be realized from the petitioners, all the petitioners, and the petitioners are aggrieved by of the Excise Commissioner. Under the old rule, I have taken a specific plea in my counter affidavit that this order can be challenged before the Board of Revenue under Rule 62 of the Odisha Excise Rules, of the old rules.
And there is no stay anyway.
Nothing.
Stay
Stay there. Stay can continue. They can approach the Board of Revenue.
Your Lordships,
They can continue for 6 months.
Just apprise your Lordships. It's a matter without jurisdiction, no show cause, nothing. And your Lordships, actually, this does not have any substantial provision.
The first matter, who's appearing in 26231?
I'm appearing, madam.
There's no stay.
Your Lordships, there's a stay in my matter. All the 3 matters, your Lordships, I have stay.
No, there is stay. There is stay in one case. So
Your Lordships, in fact, it was my matter in which stay was first taken, your Lordships. That is serial number 7.
So let the stay continue. Let the Board of Revenue continue.
Your Lordships, just apprise your Lordships. Your Lordships, probably it will not be covered by this question of alternative remedy. Your Lordships, we are all manufacturers of IMFL in state of Odisha. We are getting our raw materials from outside state of Odisha, and we pay an import fee that's covered under that act and permit. What they did is, on basis of an audit objection only, similar audit objection was there in 2009 and the department had dropped it. In 2013, on the basis of similar audit objection, they say that now this very transaction will also be covered by transport fee, whereas the definition of transport fee is there is a removal of goods within the state of Odisha from a place within the state of Odisha to a place within a state of Odisha. That means the consignment arises within state of Odisha, terminates within state of Odisha. Import is bringing into the state of Odisha from some other state. They are mutually exclusive definition, your Lordships. The audit, it's only audit, your Lordships. There is no, this particular order is general. There is no individual application of mind. There is no show cause, nothing, straight pay. Otherwise, you stop your business.
No, but anyway, since you have an interim order, we continue the interim order, let the Board of Revenue dispose stuff.
Probably, your Lordships will just look at all the other impugn annexures. They said that we are collecting because a higher authority says. So it's probably go to from Caesar to Caesar's wife only.
No.
Your Lordships, kindly see all the impugn annexures, your Lordships. They said you're just doing
And
it.
if that will be the approach, then there is no question, meaning of alternative remedy.
Alternative remedy is not always
Board
a
of
bar.
Revenue is competent enough to decide that whether imposition of this penal tax or this realization of without
jurisdiction, Your Lordships,
in accordance with law.
It's completely against the statute without
That you
jurisdiction.
can raise this point
Without
with the Board of Revenue.
justice, Your Lordship, that's a good ground to come before a writ court and not be relegated to the alternative remedy, Your Lordships. We do make out a case that why we should be here. Your Lordships will kindly allow us.
Excise Commissioner. We'll permit you to raise all these points.
Your Lordships will also kindly see, Your Lordships, we had pointed out that, Your Lordships, this counter which has been filed.
In which one?
Counter which has been filed, has been filed by OP number 3. Not a word from state, Your Lordships. Only OP number 3. Only OP number 3, Your Lordships. It's not even that the others have given them the power to file a counter on their behalf. Only OP number 3, the state should have been called upon to answer this, Your Lordships.
OP number 3 is the Deputy Commissioner of Excise. He has filed the counter
Lordships, it's a question that no tax, Your Lordships, and no tax. The state has to answer that question, Your Lordships.
You are questioning the order of the Excise Commissioner, and the Commissioner has
see our grounds.
And in para 4, I have specifically stated that this order is to be challenged before the member Board of Revenue.
They have already taken the ground that the policy, the government policy has so and so entry of so rates, and therefore we are doing it, Your Lordships. Short question, Your Lordships can dispose it of. Totally without jurisdiction. Covered by several decisions of the Supreme Court that you cannot raise it merely an audit objection.
Or in all the audit
objection, Your Lordship, there's a reason why. This very department had dropped the audit objection. Your Lordship, just kindly look at Annexure 10-11 of my brief, Your Lordships, that is at the serial number 6, Your Lordships. The department has dropped that audit objection. 7, Your Lordships.
So all these pleas can be examined by the Board of Revenue.
And Board of Revenue is an independent body, not in all audit objection cases. Your Lordship may kindly remember, Your Lordship is relegating the case to government to take a decision. But here is a case where there is the Board of Revenue who is to examine. Board of Revenue is not within the department. It's a separate body. So Board of Revenue, they can raise all these points before
in
the
all
Board of
these
Revenue.
petitions, challenges
That is a statutory body
to the orders passed by the Excise Commissioner
under Annexure 5,
requiring each of the petitioners to pay single court's transport fee in terms of the Odisha Excise Act and rules thereunder. Full stop. The common ground on which the challenge has been, one of the common grounds on which challenge has been raised to the impugn orders is that it is without jurisdiction, and that considering that the transactions were of single court's import, unquote, no single court's transport fee, unquote, can be asked to be collected along with the import fee, which according to the petitioners has already been paid by the paragraph. While issuing notice in these petitions, interim orders were passed by this court, staying the impugned orders. Paragraph. In the counter affidavits filed in these petitions, one of the defenses raised is that the petitioners can go before the Board of Revenue to question the impugned orders of the Excise Commissioner.
Under Rule 62 of Odisha Excise Rules 1965.
Under Rule 62.
This is old because your notice is also under old rules.
Under Rule 62 of the Odisha Excise Rules 1965.
65. This is the old rule.
Since the impugned orders were passed.
Yes.
But we are challenging the virus of the
prior
entire
to 2017. Full stop. Right. Paragraph. In that view of the matter, without examining the merits of the impugned orders at this stage, the court directs that each of the petitioners will be permitted to file appeals against the impugned orders of the Excise Commissioner before the Board of Revenue on or before 2nd January 2023. and the delay in filing such appeals will stand condoned by virtue of this order. Full stop. The Board of Revenue will then hear the petitioners and pass appropriate orders in each of the appeals in accordance with law.
6 months.
Within a period of 6 months thereafter. Full stop. Till such time, the interim orders passed by this court will continue. Full stop. The court clarifies it is not expressed in given merits. It is clarified further that the petitioners will be permitted to urge all their submissions raised in these petitions before the Board of Revenue. Right.
Item 78.
No. Item 78, I have no instruction.
No instructions dismissed.
Item number 79.
79, my lord, no instruction.
No instructions dismissed.
Item number 80.
Item 80, my lord, instructions. 81 also?
No, 81 is there, ma'am.
All right. 80,
In 81, the petitioner has challenged the illegal demand notice of the shortfall of MGQ during the closure period. And this case is covered by this honorable bench order. I've supplied the copy only.
That's 81, my lords. The order of the Superintendent of Excise is under challenge, my lords, under the 2017 rules, my lords, and appeal lies to the Excise Commissioners.
No, but if it's covered with this
Yes,
judgment.
my lords, the difference, my lords, is that in judgment, there was no dispute with regard to the facts. And second, my lords, the original location was not an objectionable location. Here, my lords, first there was a relocation because the location was objectionable.
No, this is not
Let's let him go before the Excise Commissioner.
It was because the government's order came, we have to shift the shop from the national highway. For that period, the shifting was, that temporary closure was there. It was not an objectionable place.
My lords, the case that has been, my lords, handed over, my lords, if I may show those relevant parts, my lords, where there's a
You not even filed a reply, sir.
My lords, we haven't filed any counter.
How can you say it's different on facts?
Well, this has been given to us.
We'll ask the interim order to continue. Let the Board of Board of Revenue.
No, my lords, Excise Commissioner. This is under
in as much as an appeal lies before the Excise Commissioner under Rule
252 of the Excise Rules 2017.
Under the Excise Rules 2007, 252 of the Excise Rules 2017. The court directs that the petitioner will file its appeal before the Excise Commissioner against the impugned order on or before 2nd January 2023. And the delay in filing such appeal shall stand condoned by virtue of this order. The Commissioner will hear the petitioner and pass appropriate orders in accordance with law within a period of 3 months thereafter. Till such time, the appeal is disposed of. The interim order passed to this court on 22nd July 2016 will continue. It is clarified that it will be open to the petitioner to raise all pleas urged in the present petition before the Commissioner in the aforementioned appeal.
Along with the covered judgment, ma'am.
Don't have to mention all that, sir, please.
Item number 82.
Lordship, I'm appearing through VC.
Yes.
Kindly permitted to withdraw with a if fresh cause of action arises to file.
Or counsel the petitioner seeks leave to withdraw the present petition with liberty to file a fresh petition if any cause of action suffices. Disposed of is withdrawn with liberty. Yeah.
Item number 83.
They're all in progress.
And the memo is taken on record. Disposed of is infructuous.
Sorry. Item 84.
84, I'm appearing for opinion number 3, my lord.
Or none appears for the petitioner. Dismissal, not prosecution.
Item number 85.
My lords, I'm appearing in 85, my lords.
Yes.
I'm appearing on. I'm audible, my lords?
Yes, please.
My lords, please. My lord, this is a writ petition which is challenging a seizure notice issued to me on 12th of June 2017, seizing a total quantity of 15,000 odd metric ton of the work goods which are lying as work in progress in my factory. The entire seizure, my lords, is based visit, which was from 2nd of June to 7th of June 2017.
I think this is going to take some time, Mr. Raghavan.
My lords.
Thank you.
This will take some time, I think.
Yes, I may have to show the records. My lords can have it. I can come down on Monday physically to show the records.
Not Monday, sir. We'll fix it some other date.
It's a straightforward matter because, my lords, I'll just point out what is the thing, my lords. Once a seizure is made by the department, in terms of section 110 of the Customs Act, within a period of 6 months from the date of seizure, the department is required to issue show cause notice for demanding the duty. There is an additional 6 months time provided under law for them to seeking extension to issue the show cause. Though the seizure was on 12th of June 2017, till date there is no show cause notice. In fact, my lords, these are all goods which are lying as work in progress. In their seizure memo itself, they admit the stock taking was taken, the goods tallied with the SAP records, because the entire accounting of these goods that I manufacture, my lords, there is a barcoding which is done. Each and every quantity of the coil is barcoded at the time when it starts its journey for manufacture, and all of them are lying in my factory on the date when they came. They say that all work in progress. You have not recorded this as finished goods. Therefore, these are excess quantity of goods. Therefore, they are liable for seizure and consequential duty, etc. I, my lords, gave complete details to show these are all not fully manufactured goods, because HR coil, from HR coil I manufacture CR coil, cold roll coil. These are all stainless steel products. Therefore, there is no question of non-accounted. Each and every quantity is accounted for. SAP records are there. Department themselves admitted that all the records, the quantities are all matching. Since despite that, they seized the. I filed miscellaneous application before this honorable court. Honorable court permits me to clear the goods, use the goods for further manufacture. I have manufactured, I have sold the goods on payment of excise duty or GST, because from 1st July 2017, GST was introduced. Till date, there is no show cause notice alleging any clandestine removal or any goods non-cleared without payment of duty. This entire seizure is completely perverse. They just wanted to harass us. They did not accept our contentions that these are all accounted for goods. My only request is to quash this seizure, allow them to direct them to release the bond that I have given. That is the entire case. There is not a single evidence to show that the goods were physically removed. In fact, on the date when they came, they found that a number of trucks were loaded, totaling to about 300 metric ton. For each of the trucks.
You've been permitted, Mr. Raghavan, by an order dated 13 July 2017.
My lords.
You've been permitted to remove the goods provisionally.
Yes, we have cleared the goods on payment of duty.
We just have to hear it finally, sir. There's no question of any further interim order now. We only have to hear it finally.
Yes, my lords.
All right. You say pleadings are complete in the present petition. It is stated that this will require some time. List for final hearing on 23rd March. 23rd March. 23rd March.
Obliged, grateful.
Item number 86.
Deeply.
Item 86. In this case, Mr.
Item 85, I am appearing for the department.
All right.
Item 86, Mr. Mahanti, senior advocate, is appearing, but in this case, file Voklanama on 23rd 9/2022. And that the name of the Mr. Mahanti had not referred in the court list.
Which Mahanti? Mr. H.
Madam, I pray.
Which Mahanti?
I have filed a
Mr. Mahanti, full name?
Pradipta Kumar Mahanti, PK Mahanti, senior advocate.
But senior advocate's name is never shown in the cause list.
The associate, madam.
Who is the associate?
Madam, I am Mr. Mahanti, associate.
No. What is your name, sir?
PK Naik, Prasant Kumar Naik.
The name of Mr. PK Naik, advocate, be shown appearing for the petitioner in the cause list. Okay. You have appeared now anyway.
Madam, I have filed a miscase for amendment. In the
states that he.
State has not filed counter.
15761.
Madam.
What is this amendment?
Madam, amendment is formally in nature. Only, Madam, your lordship kindly see page 5. Proposed amendment. Madam, amendment is formally in nature, known.
For the reason stated, the application allowed the amendments is prayed for. A permit we carried out. This is without prejudice to the rights and context of the opposite parties.
Yeah.
All right. What is this 9929 of 22?
Lord, in this case, I am appearing for opposite party number 13, my lord.
Status.
They have
Is there an interim order, sir?
Yes, yes,
Yes, well, that's why they have taken an
All right.
advantage
In
of that.
9929 of 2022, you say the interim order of status quo passed by this court on
3/8/2022.
3/8/2022 is made absolute during the pendency of the present petition. Then main petition, you say last opportunity to the opposite parties to file the replies within 8 weeks, rejoinder for the next date. It's April. Right.
Item 87.
Oh, like.
87, my lord, I have challenged the demand issued by the Superintendent of Excise Rourkela. My lord, I will file the appeal in view of...
Before the commissioner?
No, to the collector, my lord.
Collector, is it? Appeal is to the collector?
Superintendent, lord.
Yes.
In view of Rule
All right.
250
Counsel, the petitioner seeks leave to withdraw the present petition, liberty to file an appeal before the collector in terms of rules?
Rule 250.
Rule 250 Orissa Excise Rules. If such a plea is filed not later than 2nd January 2023, accompanied by an application of condemnation delay, citing the pendency of the present petition as the reason for the delay, it will be considered on its merits by the appellate authority. The court clarifies it is not expressed any of the matters. The appellate authority will dispose of the said appeal within a period of 3 months thereafter. That's it.
Item 88.
88, my lord, on behalf of Mr. A.K. Patra, my lord, kindly be taken up after launch, my lord.
No, we are not free.
The very last occasion, there is a direction to file inquiry report relating to, my lord, distance of different excise shop, my lord. Because I have been added as here as OP number 5. He has applied for on-shop. That has been rejected by the government. That has been challenged here. So because that restrictive due to restricted distance as stipulated under Rule 26, that is 420 meters from the religious institution. On that score, the government has rejected the proposal.
Well, what I find from the record,
sought for a last opportunity, file some affidavit.
No. Your lordship may kindly have a glance in the record on the records. The ground on which the proposal was rejected, that one Satya Sai Seva Sadan is situated within 420 meters of the. Now the question which is raised by the petitioner is that Satya Sai Seva Sadan is not a temple; it is a Seva Sadan. So it's not within the restrictive.
No, and he also says there are other IMFL off-and on shops.
Yes. So far as that is concerned, the order of the court dated
14th October.
One second. But the order passed by the government here is under challenge. If a lordship sees Annexure 1, just Annexure.
No, they were to file an affidavit. They don't seem to have filed that affidavit.
I'll just submit one sentence, Lord. If a lordship sees this Honorable Court SRB Transport, that says, Lord, this rejection order, Annexure 7, page 31, your lordship will be privacy convinced that this should go back to the government for reconsideration. They have not assigned a single region. Kindly see, Lord, page 31. On this ground, my lord, and SRB Transport, kindly see, Lord, para 22. Kindly see, Lord. But absolutely arbitrary exercise of power.
Annexure 7. Which annexure are you saying?
This is the order, no?
No, which annexure?
Annexure 6, man. Annexure 6. Page 30.
6, page 30.
Page 30, Lord. Kindly see this one. Lord, your lordship finds a single region, then my lord, probably I'll not be correct in saying that it's without any regions.
All right. The challenge in the present petition is to an order dated 31st March 2022, whereby the government has rejected the proposal of the petitioner for grant of a new IMFL restaurant on-shop license in the name and style of Single Courts Hotel Mehfil in Moza, Chandipur, Gram Panchayat, Rasulpur, PS, Wakia, in the district of Jadpur for the remaining period of the year 2021-22. 3 months are left, sir, in 22 now.
Yes, Lord. 22, Lord, that will continue. Application that will continue. Lord, my land friend knows it.
That will survive.
That order is there.
It is seen from the impugned order that absolutely no reasons have been granted, have been indicated why the application of the petitioner is being rejected. Paragraph. Although reasons were furnished in the counter affidavit filed in the present petition, as can be seen from the order passed by this court on 14/10/2022, more questions were raised as a result of those reasons. Full stop. It appears to the court that there are many factors that had to be considered department, which were not considered by it. And the order should itself spell out the reasons for rejection. Full stop. Those reasons cannot be supplied by way of counter affidavits filed in the challenge, in response to the challenge to the rejection. Full stop. Paragraph. On the short ground that the impugned order is a non-reasoned one, it is hereby set aside. The matter is remanded to the government to once again examine the petitioner's application and in the petitioner hearing to pass a reasoned order thereon, not later than 2nd January 2023, and communicated to the petitioner within a week thereafter. If aggrieved by such order, it will be open to the petitioner to seek appropriate remedies in accordance with the law. The court clarifies it has not expressed any view in the matter.
Yes. Grateful.
My name may be reflected as OP number 5.
All right.
I'm only appearing on behalf of Mr. Patram, Lord. He is not there.
All right.
Item number 89.
89, my lord, permitted to withdraw.
Counsel, the petitioner seeks leave to withdraw the present petition. Dismisses withdrawn.
Item number 90.
My lord, here, my lord, the petitioner being a restaurant owner, he intended to obtain an on-shop license. Accordingly, he submitted his applications. Then, in view of the Rule 51, the inquiry is conducted. Also, may see the Annex of 4, page 64. Page 64, that starts with 64. I would like to bring Lordship on page 65. Next page. May I read, my lord?
No, they have not filed a counter, sir. Notice
We have
is
filed
issued
a
on
Counter yesterday I have received.
Returned.
First, same order, my lord,
It does not come
without
on record.
I have received counter. Same order, my lord, without giving any speaking order, my proposal for on-shop line
So
has
same
been
order
rejected.
can be passed for this also.
Yes, same order, along with your lordship's judgment, where I was the arguing counsel, lordship has categorically stated that any objections filed after that 15 days, that will be summarily rejected.
Same order, except
Same
that
order,
this is
Lordship
Golden
can-
Palace Hotel and Restaurant. Then this is Moza Kotadwara GP Ragadi Tehsil Banki District Cuttack. And for the remaining period 2022-23. Same order.
Same order, my lord. Yes.
I think
There is no legal embargo.
instead of 2nd January, you say 3rd January.
Lordship's judgment may be taken care of.
No, you all points urged in the before this court are permitted to be urged before the commissioner. Right.
Before this government. State
Because before
There is no legal embargo, my lord. They have without giving a
this
speaking order.
appeal is before the
Secretary,
Secretary Department.
Excise.
Secretary Excise Department.
Previous case also Secretary Excise.
Excise Department. All right.
Command may reconcile. Lordship may fix a time limit so that
Here we have by 3rd.
That 2nd January is that case, this case.
All right. 3rd. No, this we keep for 3rd. All right.
I will file the entire repetition so that enabling the state to.
You will raise all questions there.
Right.
One faster. Item number 54, passed over matter. Passed over matter, item 54.
In this case, the petitioner is a vast contractor who was assessed under section 12(4) of the OST Act for the period 2001 and 2. And a demand was raised. And challenging the said order of assessment, the petitioner went before the first appellate authority on the ground that the claim towards labor and surcharge was not allowed as per the claim of the petitioner. And the first appellate authority, after verifying the documents and the books of accounts of the petitioner, allowed the appeal in part, and the demand was reduced. Being aggrieved with the first appeal order, the state went before the tribunal in second appeal. And the ground was that the first appellate authority has allowed higher rate of percentage of labor and towards labor and service charges. And the tribunal, in a very mechanical and casual manner, disposed of the second appeal.
Something else.
No.
Sure.
Not now, my
Next
lord.
matter.
It's the next matter. I'm sorry.
It's all right.
It's
Just
not-
keep it.
The tribunal, in a very mechanical manner, disposed of the second appeal and remanded back, set aside the order of the first appellate authority as well as the assessment order, and remanded back to the assessing officer with a direction to redo the assessment basing on the newly amended Rule 4B, which was amended, came into the effect from 2009.
So
Whereas my
prospective-
assessment.
it has only prospective application. The
Retrospective-
rule has only prospective application.
Yes.
No, that is retrospective with effect from that 30th July 99.
Actually, it has been given retrospective
Yes,
effect.
yes,
is
yes.
it? Oh, I see.
The notification has given effect, retrospective effect.
Oh.
And other questions that.
See, you not challenge the virus of that amendment.
Now that has not been challenged.
Then
Then
it has to apply, sir.
And other issues.
I know. Okay. They can rectify it by this. Yes, sir. Then it has to go back, sir.
That my question of law in page 10.
I know, but that rule will apply. The question of law is Rule 4B does not apply.
Then another question I want to raise, my lord.
No, only one question has been framed, sir.
Yes, that
10 July 2015,
Yes,
only
sir.
one question has been framed.
Yes.
You say on 10 July 2015, the following question was framed for consideration by this court. Reproduce the question. Paragraph. Admittedly, the amendment to Rule 4B of the Orissa sales tax rules was given retrospective effect from 1/4/1999.
My lord,
No,
30th July 99.
30th July,
Yes.
31st or 30th.
30th.
From 30th July 1999, which covers the period in question.
My lord.
That is 2001-02. Full stop. The virus of the said amended Rule 4B has now been questioned by the petitioner. Paragraph. In that view of the matter, the court is unable to find any error having been committed by the tribunal in remanding the matter to the assessing officer for reconsidering the issues raised in light of the above amendment to Rule 4B of the OST rules. Consequently, the question framed by this court is answered in the negative, that is in favor of the against the revenue. The STREB is dismissed.
Matter listed on additional supplemental list for admission. Item number 1, WPC 18799 of 2021.
My lord, may kindly see the
There
letters
is
which I have filed.
Order of the Honorable Apex Court, which is at flag Y. I don't know why some persons had been there and all your lordship's order has been affirmed there. At flag Y, your lordship may see.
What can you share that?
Here people are contending that we will abide by your lordship's order, but the
Can you share
contrary,
that order? Which order?
there at flag Y.
But it is not which I just take.
For the 24th August order.
Yes, sir. Right. Where your lordship said any interim arrangement will frustrate the purpose of the act. I don't know why. What was the need? Anyways, that all the orders have been affirmed. Now,
See, it is seen that.
So what is
on 27th of September.
Okay, there are some other.
My lord,
It's the same case, my lord.
I may be permitted to place the current status. Your lordship may kindly have a glance to that letter which I have submitted to your lordship. This is the intimation of Housing and Urban Development Department. No, it is just a minute. Sir, in inviting to the subject cited above, I am to inform you that the draft of the tentative Odisha Apartment Ownership Bill prepared by Law Department earlier along with kind opinion of the Learned Advocate General and the draft Odisha Apartment Ownership and Management Bill as suggested by Learned Advocate General has already been submitted to Law Department by so and so. Enable the Law Department for preparation of final draft of the bill. On receipt of the bill from Law Department, expeditious steps shall be taken by this department to obtain kind approval of the State Cabinet for laying of the bill before the Honorable Odisha Legislative Assembly for consideration. It is therefore requested to kindly appraise the question.
All right.
So, your lordship may kindly vision, I want to appraise your lordship that from today the assembly is going on for 1 month.
Till 31st December.
Till 31st December.
So it will be passed now.
We hope and trust that within
hope and trust.
It will be done. Your lordship may not record my statement, but within this period, the law department will clear and the cabinet it will be placed before the assembly.
In 2019 also the same submission was made. Now we are in
we are sufficiently we have sufficiently proceeded. Don't say like that.
No. I'm saying what is on record.
My lord, I believe the petitioner has to acknowledge that it's because your aegis of this honorable court, 2019, your lordships and your orders were not there.
You can
so in 2020, your lordship has
been
been
posted to first week of January. First week of January for further orders.
It is noticed that especially petition was filed against the order dated 24th August 2022 of this court in the present petition, which was dismissed by the Supreme Court. Especially petition, then in bracket you say SLP civil diary number 28288 of 22 bracket, which was dismissed by the Supreme Court on 4th November 2022. By the following order, you just reproduce the order of the Supreme Court, paragraph. Mr. D.K. Manti, learned additional government advocate, has placed before this court an advice written instruction received by him on 23rd November 2022 from the Principal Secretary to the Government, Housing and Urban Development Department, stating that the draft Odisha Apartment bracket Ownership and Management Bill, along with the opinion of the learned Advocate General, has been submitted to the Law Department for preparation of the final draft of the bill. It is stated that the final draft received from the Law Department will be for Legislative Assembly, which is currently in session.
Correct. After approval of the cabinet.
No, after approval of the state cabinet.
Yes.
Paragraph. List on. We'll have done the opening day, 2nd January. 2nd January.
Third, maybe.
Okay.
Third.
Secondly, Your Lordship, there was another direction on 27th of September. Your Lordship may see kindly para 9 and 10. They were to file an affidavit indicating what they do mean by the word completed, because by that interpretation, the entire Your Lordship's order is being frustrated. They are trying to circumvent Your Lordship's order. The word now 2 months have passed. They cannot even explain what do they mean by the word completed. No, it's absolutely astonishing, Your Lordship.
Lord, I don't understand why Mr. Agarwal is so aggressive towards the government.
No, that was a court direction.
On your suggestion, we are doing something.
This is a court direction only.
No, which
not my direction.
It's
not adversarial litigation.
It is an adversarial litigation. Why are you in?
Why? Because I am saying, my lord, now Your Lordship may see my affidavit on the basis of which this direction was issued.
Let final act come and then we will see all these interpretations.
They don't want to follow the court's order, my lord. Your Lordship's direction is there. They really don't want to follow it.
All wild.
I'll just take a minute of Your Lordship why this problem is arising. Your Lordship, my affidavit dated 16/8/2022.
Yes.
Then my humble prayer is that to comply that order, Your Lordship may kindly.
No, my lord, this is not fair, my lord. I'll just 1 minute, only 1 minute. At my affidavit dated 16/8/2022 at page 13, that verification issued by the ORERA. Your Lordship may kindly see page 16, column number 10. Affidavit dated 16/8/2022. It starts from page 13, the clarification of ORERA, and relevant portion is at page 16, column number 10, completion certificate, occupancy certificate.
Page 16.
Page 16, yes, sir. Yes, column number 10. My lord, the RERA Act recognizes certificates issued by the competent authority which exercises authority over land under its jurisdiction and has powers to give permission for development of such immovable property. As per the Odisha Development Authority Act, only occupancy certificate is issued by the development authorities and planning authority. Hence, only occupancy certificate will be accepted for the purpose of RERA Act and not the completion certificate. So it is only when the occupancy certificate is issued, a project is deemed to be complete. Now, this confusion arose because of page 9. Page 10, Your Lordship, because of this very affidavit of the public notice issued by the IGR.
This has been stayed.
No, this has not been stayed. It's a confusion just arose because the IGR, Your Lordship may see, says
don't fall into this category.
Yes.
If it is completed before
completed, yes. So now the RERA cannot fall back on this qualification. It is valid. So I pray till next date, let the authorities abide by this clarification. I don't want anything more. Can the RERA advocate dispute it?
Lordship, I am handicapped today. I have not brought my file because
this is not the way to submit, Your Lordship.
I could not see the additional list, my lord, yesterday.
My lord,
it is the RERA's own order.
My lord, may I be of assistance?
What I am praying, my lord, is taking up this matter on January 2nd, my lord. But that time I will also take instruction.
This is an extremely important issue because the projects are being completely taken away from the RERA Act. They don't.
If my dear
it is outside the purview of Your Lordships. The RERA Act will not apply to them.
No. But are there projects which are being granted registration because of this clarification?
No, my lord.
Yes,
that is a different issue.
Let him show a single instance.
Yes.
Let him show a single instance.
I have many instances now.
You show it by affidavit of at least 5 persons.
RERA, my lord, will not give any registration, my lord.
Now the RERA,
the IGR.
IGR, my lord.
No. Now once they say that completed projects will not be falling under the RERA Act, that is before commencement of RERA, whichever is the project, will not fall under the RERA Act. Registration is still being granted by the IGR, not RERA.
I am on the point that only when a project receives an occupancy certificate, it is deemed to be complete and not by the completion certificate, because the completion certificate is issued by the architect, who is not a competent authority under the Act. The competent authority has been defined, who says it's the local authority who is giving you the building permission.
Who's appearing for the IGR?
I am appearing.
So you have to clarify.
May I submit one thing to you? Whatever issue my learned friend is now raising regarding completion certificate, occupancy certificate, I think all these are will be answered in the new Act. Let the new Act. Please, I request you. Let the new Act come. Your Lordship will see the new Act, whether these issues are also addressed and these issues are also replied in the new Act. And if that is nothing, then we will give an affidavit.
Or can we do one thing? We'll say any registrations granted on the basis of this clarification of 14 July.
That is already happening.
No. We'll abide by further orders of this court.
Let this clarification be abided. Serial number 10, every statutory authority
abide by single instance is showing.
I have the instance. My lord, let all the statutory authority by this clarification. Only this much I want. This clarification at serial number 10.
My lord, no one is getting registration.
My lord, how they're objecting to their own circulars. Registration. Then let the statutory
circular. You saying that
let the statutory authorities abide by this clarification at serial number 10. I only pray to till the next day.
My lord, just 2 minutes of your lordship's indulgence. What your lordship has fallen from your lordship, my lord may pass that order. I'll tell you, my lord, why. My lord, we are the sufferers. No, my lord, as far as our knowledge goes, my lord, no sale deed. Contrary is my instruction, my lord. With all due respect, my lord, contrary to what my friend from the petitioners are saying, today, as of today, my lord, no sale deed is being allowed to be registered, including, may I add, my lord, including projects where people have been saying in 2002, the second owner is trying to resell it for their may I owners,
that is for abandoned
may I my lord, just bring it to your lordship notice. Sale deeds where owners are trying to sell off their apartment which they had got in 2001, 2002, 2005 for their personal purposes, medical purposes, also stalled. Number one, my lord.
Yes.
So, my lord, if your lordship passes an order saying that no sale deeds will be registered, it will, my lord may pass that order because that is what is not happening today as well. But now, my lord, what my learned friend is trying your lordship to pass an order saying that no, my lord may not pass that order, my lord may only pass that order. This has to be strictly adhered with. That will, my lord, rewrite RERA Act. May I, my lord, if my lord will give me a hearing, my lord, I can take your lordships to specific 3-4 sections of RERA and ODA Act, which my learned friend is saying is not correct, my lord. So, for abundant caution, no, my lord, for abundant caution, as it fell from the, as my learned friend from learned senior from the state is saying, my lord may say that whatever is, if at all any registration is happening, they shall be subject to your lordship conditions. Because what my learned friend is now asking your lordship to do and requesting your lordship to do, that your lordship to pass a positive order saying that this has to be complied with. That will rewrite.
No, 1 minute. I think the point being raised is this. When will an occupancy certificate be issued? That's all. That's the only point.
No, my lord. My lord, with all due respect, my lord. The point that is being raised today is whether projects which have been completed.
Yeah. What is the meaning of completed?
Yes, my lord may kindly see RERA Act. My lord may kindly have it RERA Act because we can. I can
there in the RERA Act.
Do it, my lord, in a few minutes. My lord may kindly see para 3 of RERA Act. Section 3 of RERA Act.
Yes.
Please, my lord, needs. I'll give you. I can take it. Again. My lord, I'm sending another copy.
32Q talks about completion certificate.
Lord, section 3. No, my lord. My lord, may I take section 3, your lordship, first? My lord has section 3.
Yes.
Yes, may I read, my lord, and I quote. Prior registration of real estate project with real estate regulatory authority. 3.1. No promoter shall advertise, market, book, sell, or offer for sale or invite persons to purchase in any manner any plot, apartment or building as the case may be in real estate project or part of it in any planning area without registering the real estate project with real estate regulatory authority established under this act. My lord, the next proviso is very important. Provided that projects that are ongoing on the date of commencement of this act and for which the completion certificate has not been issued, the promoter shall make an application to the authority for registration of the said project within a period of 3 months from the date of commencement of this act. Now, my lord, my humble submission is, my lord, proviso to section 3 talks about for which completion certificate has not been granted. My lord,
but look at this circular now. Look at this 17th July.
My lord, my humble submission is...
No, just come to that 14 July 22.
My lord, there has not been served. I have no idea what is served. I'll take a look at it.
No. The word you used here, unfortunately, any apartment completed, not in respect of which a completion certificate has been issued.
Correct.
So that's the confusion.
No, my lord, then...
If you say that the word completed means where a completion certificate has been issued.
My lord can clarify that, but cannot be occupancy certificate. Why, my lord? Because occupancy certificate has also been defined under RERA.
Completion certificate
has also been defined.
So completion certificate also has to be issued by an authority. So his...
Yes, your lordship. Here in Odisha, the architect is issuing it.
My lord, may I clarify that? My lord may kindly have ODA Act. My lord may kindly have ODA.
So you want us to do all this without the government filing a reply?
No, that's what I'm saying. Because my learned friend is stressing.
But the government was asked to file a reply in September. We are in November. And the government is not going to clarify.
Till then, this clarification may be abided by the authorities. The clarification of RERA only.
That will create a domino effect, because what my learned friend is now asking to do is your lordship to substitute completion certificate word in the proviso to section 3 from completion certificate to occupancy certificate. That is rewriting the RERA Act.
Your lordship,
that is precisely my point, my lord.
Then see the definition of the completion certificate.
Please, my lord.
I'll just take to...
Lord, if this can be given a copy, we can also come to the aid.
2Q.
My lord, neither these affidavits are being given
a copy. But this 14/7/2022 seems to indicate that RERA Act itself will not apply.
Yes.
No,
so that is
RERA
adding another.
No, RERA Act will not apply where projects which have been completed.
So they are completely out. They need not come before your lordships.
Yes, my lord.
Then all this definition that you're referring to will have no meaning.
No meaning.
My lord, if I may clarify. My lord, no projects which have been completed and not completed, completion certificate has been issued under RERA. That is the mandate of the Act, my lord. My lord, why? My lord, I'll give you a small example, my lord. I'll give you an example. My lord, the RERA Act says that a builder will be responsible for any structural damage and so on for warranty for 5 years. My lord may kindly see this. For 5 years. Now, what did the legislature in their wisdom, my lord, think? That listen, a project which has not obtained completion certificate, there the builder has to do something to make sure that when it is come under RERA, they have to give 5 years warranty. Now, my lord, projects which have been completion certificate has been given. How does the builder suddenly in 2017, which has been under process for so long, suddenly give a 5-year warranty? My lord. Hence, the legislature in its wisdom said that 3 proviso, and my lord, may I add, my lord, it is already
Mr. Monty, you just now for the first time in this court read this public notice, right? You've just read the entire application. I mean, the entire concern is about this public notice.
I have not seen
and without even reading that public notice, only reading it in court, I don't know how you're arguing at such great lengths.
No, my lord.
So
no, my
the
lord.
concern is
No, my lord.
what is stated in that public notice.
No, my lord. Why I say my lord? My lord, because my learned friend does not serve us a copy. Does not give us an opportunity to file a reply. If my lord, if it gives us, we'll file a proper reply.
There's an order passed, Mr. Monty. Are you saying that you're not aware of our order?
We are aware of
if you had read our order, then you will ask yourself, what is the court talking about?
Yes, my lord.
Then you could have asked him, if you didn't have that copy of that notice, you could have asked him a copy.
No, my lord. Even in the notice,
you don't have to wait for 2 months after we pass the order to say, I've never seen this public notice.
I am not waiting.
Yes, of course. For the first time today, after 2 months, I don't know what the court was talking about in its order.
I'm sorry, my lord.
Indicate about the completion certificate.
Misunderstood.
My lord,
just come to the order dated 27th September.
Your lordship's order, my lord?
Yes.
Yes, my lord.
Para 9
my lord.
And 10.
Yes, ma'am.
So if you have read this order, you can't say, I don't know what the court is talking about.
I'm not. I bow down. I apologize, my lord, if that is how it came across.
I'm really preventing you from filing this clarification if you wanted to clarify.
No, my lord, a copy is not
are you affected? Whom are you appearing for?
My lord, we are already a party here, my lord. We are for the...
No. Are you affected by this notice of 16th August 2022? 14 July 2022? Are you affected by it? Are you affected by this notice?
My lord, all the builders will be, my lord. If suddenly...
No. If you have projects which have already been completed prior to the commencement of RERA, then you will be affected. If you do not have projects which have been completed prior to RERA, then you will not be affected.
He's representing the CREDAI, my lord.
My lord,
he's representing the CREDAI, the Real Estate Developers Association.
I have a lot of members, my lord, who are regular builders, my lord.
No. Do you have projects which have been completed, in respect of which completion certificate was issued before RERA,
yes, my lord,
and which have not yet been registered?
Yes, my lord.
That is for you to explain how that has happened.
My lord, because
it is for you to explain what has happened.
My lord, Supreme
because we are here, RERA commenced when?
2017, my lord.
7. And you are, how come for 5 years you never got it registered?
My lord, because we got a completion certificate in 2016, my lord, project.
No. So why did you not for 6 years get it registered then?
My lord, because the Act says that if you have got completion certificate, then you need not register.
Then how does this affect you? How does this affect you? Because then you're relying on the Act itself to say, I don't have to get registered.
Yes, my lord. Now, my lord, what?
Then you're relying on the Act. This circular says the Act itself will not apply.
No, my lord.
Look at the circular, what it says.
My lord, my lord, the circular is completed.
You say
abide by this.
Now, my lord,
clarification of RERA only.
My lord,
my lord, my friend is saying, I was just trying to object to what my learned friend was trying to pray, my lord, before your lordship. My learned friend was trying to pray that my lord passes an order that it is only occupancy certificate.
See, our problem is the Inspector General of Registration. I think we've said this earlier also. Every time creates a complication by saying something without informing the court. When everything is being debated, you quietly back and issue some circular, which adds numerous complications. If what you say is right, we are preparing a bill, everything should await. Why are these authorities jumping the gun like this? Why should they issue this kind of circulars?
I'm not representing.
They should also say, let us wait for the draft bill.
No, because this is otherwise restricting the registering authorities.
Then be clear about what you're saying. Use terminologies and expressions which are there in the act. They're traveling far beyond. They're using new concepts which are not finding place in the act.
May I pray one?
There's nothing called project completed. No such expression here. It only says completion certificate. So why is an Inspector General of Registration using the terminology completed?
My lord, may I pray one thing to your lordship?
Which is the question we asked. See, once the court poses a question, gives you an opportunity, you still don't come back with a clarification.
No.
My lord, I am only representing the RERA. I am representing the RERA. Mr. Mahanti is representing the IGR, my lord.
No, he is asking me. Don't worry.
Okay.
He is asking me. My lords, may I submit one thing to your lordship? In terms of this direction, we will do it within 1 week. Within 1 week, I will file the affidavit.
All right. You say Mr. Mahanti undertakes to file an affidavit clarifying in terms of the specific query posed by this court in para 9 of its order dated 27 September 2022, positively within 1 week from today. That is on or before 1st December 2022.
Just for assistance, maybe also file a reply, my lord.
Sir, nobody prevented you.
I bowed on.
You just didn't read our order. And now today you're pretending you've never seen this letter of the IGR.
No, my lord, I must.
No, please, it's a sorry set of affairs. We take our trouble setting out everything such detail in our order. And counsel come and say, we don't know what the court is talking about.
I apologize, my lord. That was not my intention, my lord. I was only trying to reply to my learned friend who was trying to...
See, the point is you are not even reading the circular that he is referring to.
No, my lord. The circular...
And you are just starting off to argue. In the midst of your argument, he shows you the circular. And you say, I'm reading it for the time.
My lord, date may be fixed to that 3rd January, but we will file the affidavit within 1 week.
No. But what happens then?
My lord, yes, because in the meantime, the RERA has been rejecting projects that you need not register because of this wrong interpretation. I pray let this clarification be
we'll list it on 7 December at 2 p.m. Yes, Lord. 7 December.
One thing I want to appraise your lord. Yes. Within 7 December, that bill part we cannot.
No, we have just quoted that. That will remain.
To your lordship's kind permission, my lord.
7 December.
Your lordship's kind permission. Only 1 minute. I have got a mild fever, and this part of my.
I'm not sitting after lunch.
Yes. Because your lordship also should take rest.